his own volition says that he doesn't want invasive treatment where the chances of his so Mr. Dr. Kishore is here. Now,
doesn't amount to judicial legislation of this.
No. But what happened was initially the high-grade bench laid down certain directions as to how to do the advance directive. That required going to multiple courts, recording the matter before judicial magistrate.
Para 198.
Then, yes.
Para 198.
Yes. Para 198. First, three-step process, very cumbersome.
There are actually the 4 judgments written. So, there's Deepak Mishra with whom Justice Kanvilkar can agree.
Yes.
Then the other learned judges also wrote separate concurring judgment.
Yes.
So, where do you get the view of the court as such?
No, everybody concurred with the guidelines. Ultimately, we only worried about the guidelines.
Only on the
Yes,
reasoning.
on the reasoning.
They wrote separate. They wrote 191 that the process by which you go to there will be 2 boards. First the board certify, then it has to go to the collector constitutes the chief medical officer, another board, the magistrate goes, attests it, and so on and so forth.
What happened was
It can be challenged in a repetition if it is refused.
yes.
And it goes on like that.
The legal issue involved in that matter is already settled in that judgment. Now only the procedure how it has to be done, that is the only thing to be deliberated upon.
After the guidelines were issued, the entire medical community, we discussed number of hospitals, it became unworkable. For a person say in Chennai or in Bombay or in Delhi, now it's difficult to go to a judicial magistrate, record it, and then when the time comes, another board has to be constituted. So then we said it's not going to work out. And then based on your lordship's suggestion, we had multiple meetings and so on. Now there are 2 parts. One is how the advance directive should be recorded, point number 1. That Mr. Kishore will address, Dr. Kishore will address.
Who are the parties in this repetition? One is you. You are
The Indian Society for Critical Care. Now, one is the recording of the advance directive. Now, when the advance directive is recorded, there has to be some safeties in recording the advance directive. This note which I am giving you, not this is a note post the advance directive. Yeah. But this note that I am giving, with this chart which I am giving, is post advance directive. As far as advance directive is concerned, Dr. Kishore has he has discussed the law from Oregon, Montana, etc. What are the safety? Because it can be manipulated. Somebody can say a false advance directive and then, because once the patient goes to hospital and if he's in comatose condition or in the critical condition.
Why don't you just read for the benefit of the bench?
Yes.
Exact advance which you want to be supplanted, changed.
Yes.
Let us just read that.
No, what we are saying is, once the advance directives are, your lordship approves the method of recording, should it be videographed, should it be by a smartphone? Because we're talking about a large country like India. Now, one method is I can put it in my will. The person can put it in the will and tell his king that when the time comes, don't have any invasive treatment. I spoke to the senior doctor from AIMS also, and the lady also told me that many people who come with terminally ill illnesses, they tell the doctor that, look, I've lived a full life, I'm well past 89, 89. Please don't put all these tubes, etc. And that's what she has also. So there is a form which AIMS has got. Now, my lord, there are 2 parts. He address on advance directives. I will come to that later. Once the advance directive is is agreed upon, then what is the step to be followed? Once there's an advance directive, then the question of getting the consent of the next of kin doesn't arise because the patient on his own volition has given, for the time being, a valid advance directive that I don't want invasive treatment. Now, basically, before going into it, just broadly what we discussed with the health ministry and what we came and I want to place
We want to again ask you, the only parties are the Government of India and this common cause.
That's all.
That's the original petition.
Who are the parties?
Now Indian Society for Critical Care Medicine.
Okay, is it a party here?
It's an intervener.
It's
They are
an
the
interview.
Yes, we argued matter the last time.
They are the applicants.
They are the applicants. And we argued the last time.
I think you are representing common cause. The original petition.
No, actually I am representing Indian Council for Critical Care Treatment.
So who appears known? Who is that?
I'm a very common cause.
So what is your view?
We are supporting it.
You are supporting them.
It's a very well-known, very good organization.
Very good.
No, and I spoke to surgeons from leading hospitals in Madras and Bombay.
No.
And also AIMS.
Now that is just run through quickly. The procedure which is prevailing as of today under the order.
Yes, yes.
Let's just take us through that. So then, you know, we can immediately apply our minds to it and then.
And perhaps, Mr. Dakar,
Yes.
you use the word will. This is during the lifetime of the person and is to be executed while he is still alive. So therefore, we have to have a proper word for the document that we are looking at.
Yes.
Living will is one of the document that is, that's one of the common phrase that is being used. Whether living will or some other
No, there are
phrase.
two phrases, living will and advance directive.
Okay.
Because
Living will also has a certain connotation. Perhaps that could also be one of the things.
But my-
Advanced directive is
I also in most legislation, as Dr. Kishore will point out, they're using the word advance directive. That is, in advance, I give a directive that when the eventual time comes, the person should not be put to agony, etc. Because what happened was, it's very difficult for the people who are his family to take the difficult decision.
Very, very difficult.
Take him on the- And as your Lordship last week pointed out, it can lead to financial ruin also, but the parties can't take a call. So
Straight away, we will come to the actual.
actually, what is the portion first?
What is the portion first?
What are the original guidelines?
What are the changes that you would like to
Yes.
incorporate? So let us just have a look at the.
My Lord, before your lordship, I want to make a brief submission.
Mike.
But he has been instrumental in drafting the Medical Termination of Pregnancy Act, and his articles have been referred to by his Lordship. Yes, he speaks with some authority.
Lord, I was a doctor for 40 years, since 1968 till 2004. Then I diversified into law,
What is your area of specialization? The medical field?
radiology,
Okay, as a diagnostic tool.
diagnostic as well as therapeutic radiology.
Both.
When I did radiology, at that time it was one.
Yes.
Later on, it is split into two, therapeutic radiology and diagnostic radiology.
And even there is a lot of specialization.
And in therapeutic radiology, there are some specialties.
Abdominal, you have all.
In the diagnostic, there are about 20 subspecialties.
Absolutely.
Neuroradiology, gastroenterology, hepatology.
That's right.
My subject was hepatology. So, my Lord, I have been a lawyer for the last 18 years, practicing in this honorable court. And I am associated with this issue right to life for a quarter of century. My first article appeared in 2005. And I have gone through the judgment given by His Lordship Honorable Justice Deepak Mishra. And there also I was an amicus in that case.
Very good.
Now I have made a small brief in which everything is there. These are the 5 sets. Right from concept, what is the moral concept, what are the legal challenges, and how different jurisdictions of the world have ensured any kind of abuse or misuse of this particular notion. So, the first law came in 1997, the Oregon Death Dignity Act. That was a statutory document, which for the first time recognized a person's right to end his life. Thereafter, upon
Asking the question
Yes.
as to what is the legal bar if a person refuses to actually receive treatment and says, I don't want any further treatment.
yes,
So is there a legal bar in law or even otherwise? Is what he
Yes.
there are 3 legal paradigms.
Because we are conferring legal right to refuse treatment, but what we are exploring is there a legal bar in refusing treatment? Because every time a near and dear one is taken to hospital, we have to sign all kind of
Documents.
bonds.
So, my Lord, on this particular issue, right to die. Right to die is a very well-defined issue in the global context.
It's not right to die in normal situation. It is right to die when very ill.
That's why in this case also,
Circumstances.
this case also, they have dealt with the Lordships have dealt with right to live with the dignity and right to die with the dignity. That was it.
There are 2 kinds of persons on the planet. One are those who add years to their life. Others are those who add life to their years. So the moral paradigm,
That is a philosophical moral paradigm. We are asking where is the existing prohibition
I beg your lordship.
But my lord,
Just one second, just one second.
just let me complete. My lord, there is only one country in the world, that UK, which have British Suicide Act 1961.
We are not on suicide. Somebody is suppose very ill.
Yes.
Now, if he is taken to the hospital, he may give an advance directive, don't put me in a ventilator.
Yeah.
But if he chooses not to go to a hospital, what happens then?
That is very well settled. This court constitution bench judgments say that everybody has an indefeasible right. If he is in his right mind, he has an indefeasible right to refuse any treatment.
Yes.
He cannot be forced to take any treatment. Here the question only arises, if a person is unconscious and he is incapable of expressing his will as to whether he wants to be continued, whether he wants to be put on a ventilator or not, then the question is, if such a person in advance says very critically ill, goes to a hospital, he knows that he may be put on a ventilator. He gives a advance directive saying that, look, should this situation arise, I don't want to be put on a ventilator. I don't want to be kept alive by artificial life-saving means. And he signs that declaration and gives it to the hospital. Then the principal.
Normally, right now, the next of kin has that authority
So that
to say whether to put into the ventilator or
the
not.
next of kin's
You
right.
want to shift it to the person concerned.
If the person concerned has given an advance directive, then it overrides the right of the next of kin, because he has an indefeasible right to decide what should be done with him. And if in his right mind he has given an advance directive, then nobody, not even his next of kin, can force him to be put on a ventilator, even if he becomes unconscious. That's the whole object of this advance directive or living will. That nobody, not even his next of kin, can force him to be put on a ventilator. Now, the problem that has arisen, because of which this application has been filed, is that unfortunately, my lord, the court, while giving legal status to this advance directive and saying that it should be honored, has put a large number of very cumbersome restrictions as to how that living will has to be executed before a magistrate, this, that, and the other, which are unnecessary. So that is why this application.
When you are seeking clarification, it's not better to go to 198 so that we can,
Yes, but I will.
what exactly are the,
In fact, we are about to go to that, but to answer my lord, just those questions, please see page 11. AIMS has got a form that patients wishes for withholding life support. This is even done today, page 11 of this spiral bound compilation. So that will answer my lord's question. That today, I mean, without advance directive, etc., I may not, but when I'm going in for this, but we've got enclosure 2, page 11. All in all.
Yes.
What section got it?
So under what law is this given?
The law in India.
There is no statutory provision saying that in extent.
Yes.
There is no statutory.
So why, if it's otherwise permissible and
Common law, yes.
why are we
not-
requiring advance directive from us?
No. This is a signature by the patient who is conscious. You see, I with so and so, I could have a critical terminal illness where the disease modifying options are no more applicable.
Plus the hospital is coming.
No, what? If I said so.
We have reached that stage.
Just because I put advance directive has to be obeyed. It still goes to the primary board, then it goes to the review board, because I'm completely unconscious. I'm not in the position, and I'm told by doctors that very often a person is terminally ill, he's not able to fully think rationally.
The better course, let us see 198.
Exactly, that's what he is telling you.
Where
Please
is
go
the
through, let us go through
practically
198.
becoming possible to work out?
And that is the only area where we have to come in, otherwise it's a judgment of this.
So far as law is
They
concerned,
are seeking.
so far as law is concerned, this judgment itself makes it very clear. Till appropriate legislation is made, this has to be followed.
Exactly.
That's what it is.
You know, see what
Sitting in the gap.
Yes.
No, no, after this judgment came, we read out to the next constitution bench saying that some of these paragraphs are not workable. Then they asked us to go back and come with alternative suggestions.
That's how you are here.
That's how we are here.
Therefore, let us
And
start.
since the 5-judge bench, only a 5-judge bench.
Let us read 198.
Yes.
You know, otherwise we are just,
Page,
that's why I'm reading it.
who can execute advance directive and how?
At page 129.
129 starts at 198. Yes, my lord, now, just to tell your lordship, to save time, your lordship will tell me what to do, I'll follow that. 175.1 is the first question.
Where you are reading?
198.1, now there are multiple.
Exactly, we got 198 points.
Yeah, just see 19, the first question, who can execute the advance directive and how? Now, just before coming to that, please come to the next question at page 1, just a bird's eye view, then I'll come back to individual questions. Come to page 176. What should it contain? Then that is discussed. Then 198.3, how should it be recorded in full?
No, we are 170.
176 is who can execute the advance directive.
You are reading not from, we are reading the SEC.
Yes, I'm also reading SEC.
You are reading not from a.
Okay.
That's
But I've got para 198 is there, Bharat?
Para 190.
Does it start with the word in our considered opinion, advanced
That's
medical
right.
directive should
That's right.
serve as a fruitful means?
You want us to read 198.1 that we have got.
Yes, then if your lordship just comes to 198.2,
Correct.
what should it contain?
Correct.
All your lordships have seen that?
Yes, we have seen that.
Then 198.3, how should it be recorded and preserved?
Correct.
Then 198.4, when and by whom it should be given effect to.
Yes.
Now, what we are given today is 198.4.
So we need not be concerned with other aspects.
No, your lordship has to be concerned because.
It's the earlier part also.
So first is recording of the advance directive, because as the Solicitor General also mentioned, lordship also put it, we should have some safeguards on this potential misuse for purpose of property or other disputes, etc. So the advance directive, which is
Has there been any empirical study after the judgment as to how many persons have actually made use of this?
but I am told that AIMS form has been
Doctor
used.
India actually,
No.
does it contain any? Because you may go to a private hospital, you may go to a government hospital, of course, but the governmental authorities are involved, magistrate and the DMO in terms of this. So you would have statistics of the practical value of this, this
No, there is anecdotal evidence, no empirical evidence.
no evidence.
As of now, there is no empirical evidence.
Actually, what happened is the directives from day one could not be implemented because it was not possible to go to the magistrate, get his permission and so on.
Because of cumbersome procedure that is now presently involved.
Absolutely.
Yes, that is the one which has.
My colleague tell me that persons who went, they were refused because they say we have to follow all the entire procedure. It's not possible.
Better we go through it. And
Well,
find out.
198 we can
Start
start
with
with.
186, what is active, this,
186, Baba?
186, it says, what exactly is advanced
Yes,
directive?
Black's Law Dictionary.
What exactly is that?
Very well. Very
In
well.
what manner this term was understood by the?
But I will start with para 184, which starts with subheading capital P, advanced directive, advanced care directive, advanced medical directive. Has all your lordships got that? Because yes. In order to overcome the difficulty faced in case of patients who are unable to express their wishes at the time of taking the decision, the concept of advanced medical directives emerged in various countries. The proponents of advanced medical directives contend that the concept of patient autonomy for incompetent patients can be given effect to 184.
Yes, you continue.
All your lordships have got it?
Yes.
The proponents of advanced medical directives contend that the concept of patient autonomy for incompetent patients can be given effect to by giving room to new methods by which incompetent patients can beforehand communicate their choices which are made while they are competent. Further, it may be argued that failures to recognize advanced medical directives would amount to non-facilitation of the right to have a smooth dying process. That apart, it accepts the position that a competent person can express his or her choice to refuse treatment at the time when the decision is required to be made. Advanced directives for healthcare go by various names in different countries, though the objective by and large is the same, that is, to specify an individual's healthcare decision and to identify persons who will take those decisions for said individual in the event he is unable to communicate his wishes to the doctor. Black's Law Dictionary defines advance medical directive as a legal document explaining one's wishes about medical treatment if one becomes incompetent or unable to communicate. A living will, on the other hand, is a document prescribing a person's wishes regarding the medical treatment the person would want if he was unable to share his views with the healthcare provider. Another type of medical directive, advanced medical directive, is medical power of attorney. It is a document which allows an individual to appoint a trusted person, agent, to take healthcare decisions when the principal is not able to take such decisions. The agent appointed to deal with such issues can interpret the principal's decision based on their mutual knowledge and understanding. Advanced directives have gained lawful recognition in several jurisdictions by way of legislation and in certain countries through judicial pronouncements. In vast majority of states in the United States, it is mandatory for the doctors to give effect to the wishes of patients as declared by them in their advanced directives. California was the first state to legally sanction living will. The United States Congress in 1990, with the object of protecting the fundamental principles of self-autonomy and self-determination, enacted the Patient Self-Determination Act, PSDA, which acknowledged the rights of patients to either refuse or accept treatment. Following this, all 50 states enacted legislations adopting advanced directives. Apart from this, several states of the USA also permit patients to appoint a healthcare proxy, which becomes effective only when the patient is unable to make decisions. In order to deal with technicalities and
Advanced medical directives is well recognized
yes,
and acceptable.
yes,
Now we have to put it in how we have to implement
yes,
so that this all safeguards must be there.
yes.
Now come to 198 and see what are the safeguards provided
All right.
and according to what safeguards require modification.
Now, Lordship will kindly come to 198.
That's correct.
Yes. Lord, I will just, with your permission, read the earlier paragraph that will give a flow to the 198. Having dealt with principles in vogue across the globe, we may presently proceed to deal with the issue of advanced medical directive, which should be ideal in our country. Be it noted, though the learned counsel for the petitioner has used the word living will, yet we do not intend to use the same terminology. We have already stated that safeguards and guidelines are required to be provided. First, we shall analyze the issue of legal permissibility of the advanced medical directive. In other jurisdictions, the concept of living will and involvement of attorney are stipulated. There is no legal framework in our country as regards the advanced medical directive, but we are obliged to protect the rights of citizens as enshrined in Article 21. It's our constitutional obligation. As noticed earlier, the two-judge bench in Aruna Shanbhag has provided for approaching the High Court under Article 226 of the Constitution. The directions and guidelines to be given in this judgment would be comprehensive and also cover the situation dealt with Aruna Shanbhag. This is that nurse who was comatose for 28 years. Okay. In a considered opinion, advanced medical directive would serve as a fruitful means to facilitate the fructification of the sacrosanct right to life with dignity. The said directive, we think, will dispel many a doubt at the relevant time of need during the course of treatment of the patient. That apart, it will strengthen the mind of the treating doctors as they will be in a position to ensure, after being satisfied, that they are acting in a lawful manner. We may hasten to add that advanced medical directives cannot operate in abstraction. There has to be safeguards. They need to be spelled out. We enumerate them as follows. Number one, they start. Who can execute the advanced directive and how? The advanced directive can be executed only by an adult who is of a sound and healthy state of mind and is in a position to communicate, relate and comprehend the purpose and consequences of executing the document. It must be voluntarily executed and without any coercion or inducement or compulsion, and after having full knowledge of information. It should have the characteristics of informed consent given without undue influence or constraint. It shall be in writing, clearly stating as to when medical treatment may be withdrawn or no specific medical treatment shall be given. It should only have the effect of delaying the process of death that may otherwise cause him/her pain, anguish and suffering and put him/her in a state of indignity. What should it contain? It should clearly indicate the decision relating to the circumstances in which withholding or withdrawal of medical treatment can be resorted to. It should be in specific terms and the instructions must be absolutely clear and unambiguous. It should mention that the executor may revoke the instructions authority at any time It should disclose that the executor has understood the consequence of executed document. It should specify the name of a guardian or close relative who, in the event of executor being incapable of taking a decision at the relevant time, will be authorized to give consent or refuse or withdraw medical treatment in a manner consistent with the advance directive. In the event that there is more than one valid advance directive, none of which has been revoked, the most recently sent advance directive will be considered. It's both like that.
Like 198.2.1, just can we revisit it?
It should clearly indicate the decision relating to the circumstances in which withholding or withdrawal of medical treatment is ordered
Now,
to.
this is a central kind of thing.
Oh,
Correct. We're talking about a country like India. The masses across social, economic status. So you've got to apply. You take, for example, a disease like cancer. You can broadly categorize it final stage, terminal cancer. Now, what if somebody says that if I am afflicted with cancer, I don't want to undergo treatment. Side by side, place side by side, the fact that, by the time he comes into that state, huge advances are made. In fact, it's happening on a daily, day-to-day basis, trials and different kinds of treatment. So, he says, I don't, if this happens, if cancer comes, finish. It's not whether it's primary, it's secondary, whether there is metastasis, nothing. He simply says, somebody says that.
it's a trigger.
He says a trigger, and he says, irrespective of whether it is terminal or whether it's treatable, he says, I don't want it. Because he's been told that cancer, and if I don't want it. He's got the freedom, he's got the choice, it's my life. But are we not, in that sense, devaluing the value of life itself?
But not that, yeah, Lordship's concern is addressed by the question that the person's decision is not the be all and end all. It instead it says that if I'm afflicted with cancer, first of all, it should be a cancer where you reached a stage where doctors, I have seen all of related.
But does it say that?
No. We'll have to read it.
What should it contain? See, the point I'm trying to make.
No, I'm just coming to that. No?
Yes.
Just sorry to interrupt. What happens is this, first of all, there's an advanced directive that should it come, typically they will say if I'm afflicted with a disease, which is difficult to cure or where the chances of recovery are remote, please, because today when a person makes advance, he does not know what he's going to be afflicted with. It could be, for example, who thought of corona?
I do it at the age of 30 years.
Yes.
Supposing I see it and I am fed up, I don't want treatment. I do it at the age of, say, 30 years. Okay, I don't touch it. So I become afflicted by, say, about 25 years. The state of the medicine.
Maybe.
is
That's why there is a.
completely transformed.
No, that's why there is a medical board. What we have contemplated is a primary board, which says that, look, no, this man can be treated. And that primary board contemplates an ethics committee which the health secretary wanted to add, which is there. Then after the primary board, there is a review board. And the review board can also take a contribute and say, no, this is a person where treatment can be, right? They say we can check this, removing the treatment after 4 weeks, after 8 weeks.
No, but then
So
they
Lordship-
should not be honoring his wishes.
No, because see, the point is,
No, but
there's Lordship.
Bhushan said that you have a complete absolute right to, decide the destiny of your life at least. When it should begin, when it should end.
Yeah, no, but the point is, I'll put it this way, bro. There are two different things.
6 weeks. Ethics committee, etc. What happens in the intervening period? Is given the treatment or not?
He's given the treatment. He's given the treatment. To answer my just Joseph's question, suppose a person at 30 says, I do, if I, in the event of eventuality of my being afflicted with the cancer, I should not be treated. The suggestion which has been made is, you have, if beyond a point, you can't simply say, don't treat me. If it's a completely curable thing. Suppose tomorrow you say, I've got a particular problem. It may not be cancer, it could be something which can be cured, but which may lead to further problems.
But
There, what I'm saying is,
so the person consciously can refuse any form of
no,
treatment.
because what happens is, in the Lordship's question, what is contingent is, the person must have terminal illness.
But it is not mentioned.
It's not mentioned, but you're also, that's why you're also now making very clear, that in the event of my acquiring terminal
The
illness,
value of life also should not be
Devalued.
You can't be doing it because particularly in the rural areas, if you're going to, make it obviously contagious. That once the idea, takes hold.
But what was haunting the bench also was the possibility of misuse. How to curb that? That's the most important. Because today, today suppose it's a lawyer. Say a lawyer is there. As the Bible says, the young may die, the old may die, but the wisest know not how soon. So that is the statement in the point is, if there is a lawyer or a chartered professional, what I'm saying is mentally alert person who can take a conscious decision. God forbid is affected with some kind of a rare disease which no known cure is there. And it's going to involve massive amounts of invasive treatment. Then the person says that don't do it. Like, just for example, in our own cases, grandmother is 94, 95. She tells the relatives that, look, please don't put me into a ventilator and drill a hole in my brain and all that. When they know they're ill, they say, if something happens, just let me go peacefully. I've lead a contented life. All my children are settled. This also is a common thing which we see.
That happens
Without advance directive.
without it. Either when you go to the doctor, like you talked about the grandmother, the doctor will tell you, see, basically it's very palliative now.
Yes.
You've got a palliative
You
division.
take her home and let her be
at home. So they abide by it and they take
Take a
nobody
call.
says anything.
they take a call here.
What is the need for all this? This will apply essentially for a very select few people belonging to a particular section of society, which we may, at least I may, describe as belonging to the economic strata, which can go into such, it will be in specific terms, instruction must be absolutely clear, ambiguous, medical treatment to be given.
I think eventually it becomes like a will.
If you follow the life of,
Eventually becomes a routine. Sorry.
follow the life of Stephen Hawking,
Yo,
at the very early age, there was a prediction.
he defied all odds.
Defied all
You should have told me some cases where a person has recovered after 21 years.
Absolutely.
Like Michael Schumacher, the race driver, he's still in a coma. We don't know what will happen. Some stem cell research will revive him. We don't know.
Yeah.
He's still alive.
The real challenge is not how to define terminal illness.
Exactly.
He's got a very interesting.
Profoundly contextual. A person who is having some certain socio-economic impairment, terminal illness will descend on him much earlier than a person who is well equipped to have advanced treatment. That's number one. Number two, terminal illnesses which have been certified as terminal illness, namely PVS, persistent vegetative state. There are recorded information where the patient has survived for as long as 20 years. And after 20 years, they regain consciousness and they became. So different jurisdictions have tried to define it differently. For example, in Oregon Capital Deputy Act, they say that if the doctor certifies that the patient is terminally ill, and with all reasonable probability, he will not survive for more than 3 months. Then that is one paradigm. Now, in other states like Montana, Miami, their law says the period should be 6 months. While the law of assisted dying in Australia says it should be 6 months for all illnesses, but it should be 12 months for neurodegenerative disorders because they progress slowly. So the real challenge is, once I as a doctor certified, along with 2 of my colleagues, that we have examined this individual, and we find that he is terminally ill, and his chances of survival are not there beyond 3 months or 6 months. That carries no meaning. So terminal illness is one of the gray areas in this entire debate on euthanasia. Now, second gray area is the definition of death. When a person dies, the earlier definition of death was that it was a cardiorespiratory failure. Irreversible and permanent cessation of heart and lungs was sufficient to declare a man dead.
Brain death is not.
Now, in 1968, the Harvard Medical School debated the whole issue, and they came out with a brain death criteria, which means irreversible and permanent cessation of brain. But that was not taken to be final, because in case of cerebral failure, cerebral loss of cerebral function, that is different from brain death. The metabolic activities are intact. even if a person is brain dead.
Like you have the near-death experience theory.
So then when we drafted the Indian law, when we were drafting the Indian law on transplantation, this question came before us. Then we use the expression brain stem. Because brain stem, that is the lower part, that is the pons and the middle of the gata, they die after the brain. And even after brain death, the reflexes remain intact, the excretion remain intact, the digestion remains intact, the perspiration remains intact, the body's temperature remains intact. So the person is not dead. So because death is not an event, death is a process. One starts dying and then continues dying. And with advancing biotechnology, people are able to reproduce 48 hours after death. Because sperms are the longest survived cells of the body. So they continue to live for 48 hours. So there are various challenges, and people have struggled with these challenges, and different jurisdictions have come out with.
So supposing you say that, just to you, that supposing in this provision, this 198.2.1, it says it should clearly indicate the decision-making circumstances in which withholding or withdrawal of medical treatment can be resorted to. If we simply replace it by saying that should indicate that the withdrawal of treatment should be made if it reaches the terminal stage.
As certified by the doctor.
As certified by the doctor.
Or as known to medical science at that point.
That's right.
The Lordship put it because now today, except one or two cancers, most are curable. Earlier it was completely not there.
That's it, exactly, with the one. So if you say the terminal, yes, then again what the doctor said, what really is terminal illness, again that will come into limelight.
Yes.
The second thing is what Bhushan, we are just taking from what Bhushan said, irrespective of whether it is terminal or not. Do you have an absolute right to say, even if it is not reached terminal, if the treatment is very costly, for example, okay, if the treatment, despite the treatment, it is accompanied with, getting insufferable pain, even before it reaches terminal, because it may be, bordering terminal, it is not yet reached terminal, it is surely going to go into the terminal stage for all you know, objectively. I say, please withdraw it. What will happen? So what do you mean by circumstances in which it will be withdrawn? How do you define, reconcile the right to life, that need to protect life, and also factoring in changes in the medical field, which is so rapid, that we do not know where we are going to reach.
But I would suggest, subject to what my colleague Prashant also said, Mr. Bhushan says, I think it will be risky or dangerous to say that even if a person is capable of being cured, he can say, I don't want to be cured. That, in my humble submission, could lead to problems. At the moment, we can confine, because today what the problem is, because this is a practical, because it's not a theoretical exercise we are doing. Today what happens is, nobody is willing to take the decision. People say that, look, I want to, till the last money, I want to spend money. But we all know that beyond a point, the ventilator, of course, like he says, the person may recover after the. I know a case of distant relative. Man was in coma. One man was in corona on the ventilator. And they're supposed to sign the form the previous evening. The wife and daughter said, we'll sign it the next morning. At 2 o'clock in the night, his fingers started twitching. Man is walking today.
Absolutely.
So these are all the what you call unfathomable things of what may happen to individuals. We are dealing with a broad case where typically a person has gone into a coma. He's not likely to recover. Say he's brain dead. As doctor put it, he's brain dead. His body can be kept indefinitely 3 months, 6 months. Who's going to pay for that? He can't be taken home.
In the United States, there is a huge controversy which is it surrounds around the insurance companies, because it's all insured there.
Yes.
So, the people, it was public funds being spent ultimately through the insurance company on cases which should be written off. Whereas if you come to England, you have the public health system.
Yes.
So there they have a different kind of problem. In India, we got a mixed kind of lot, which is perhaps better because we have both private hospitals and if they coexist together. In fact, that's how the whole theory of medical tourism comes. Which is now, which is a big thing, which is happening. People are coming, it's much more cheaper.
Yes.
You get best treatment, they go back, and much earlier the treatment is done. If you go to Canada, it's got the public health system. You have to wait for months together.
Yes, they
to even fix your tooth.
Yes, and costs. It's easier to come. In fact, my the Supreme Court has given a qualification law that this can be done only when the person is terminally ill.
Where is that?
198.4.2.
198.4.2.
4.1 also relevant because it says becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure.
Yes, that's right. That's another caveat.
I have understood. 98.2 is a format. Is a format.
Yes, yes. Like what a will is, what it must contain, you must sign
It's
it.
a format,
Yes.
which everybody has to disclose. 98.3 is how to be recorded.
Yes.
Form is to be filled in.
Yes.
Trouble, according to you, must be falling somewhere 98.3 because you are going through all stages one after the other. As magistrate, this, that is creating a lot of problems in getting a proper execution.
Yes.
So you have to, what according to you, 198.3 needs to be amended. So that
Yes.
can be made more workable
Yes.
and meaningful. With the right of safety and security of individual, protecting his rights in 21 can be.
Yes, but not only, as the Lordship put it, this main core safeguard is that when the advance directive was recorded, the man was fully conscious. He did it out of his own volition, not through pressure of relatives and so on and so forth. How to do that? That's the question. So either he can record it before the doctor, or that he has given some 9 different methods. One simple method which can, and again, we should have a method which can be easily applicable in most parts of India. Otherwise, we can have sophisticated system which may become, like this guideline became unworkable. So I would.
Will the declaration be disease specific or condition specific? Supposing what's contained going back to 198.1, 2.1, clearly indicated in the circumstances in which withholding. You've got a whole list of diseases.
That's in 198.4, at page 131.
Supposing he says one disease, and he is afflicted unfortunately by another disease which he never thought of.
Well, can put omnibus terminally ill.
So it again will depend upon his imagination.
Yes. No, the Lordship will see 131, bro.
Huh?
Page 131 in the SCC. The Lordship has got SCC volume.
We got 198.8.
198.4.1. As Ravi pointed out, 198.4.1 should be read first.
Yes, terminally ill.
Yes, in the event the executor becomes terminally ill. And as doctor pointed out, some countries say.
That's not the point. The point that I'm making is, if you go and really on it should clearly indicate the decision relating to the circumstances in which withholding of.
Yeah, I agree with the Lordship point. Whether it should be cancer or it should be what we call a brain injury.
Or is it the condition?
Condition. Yes.
It's not, if he says, supposing he says this, a particular disease, I'm say cerebral stroke. It's pretty bad, it can progress and many of those cases you can come back. Most of those cases, Alzheimer's.
There's no hope of the man, gentleman, ever getting, he's alive because he's not. 2-3 years also a person can be in Alzheimer's, he may not even recognize his wife.
So what you're saying is this condition
should be 198.4.1 and.
That is only following the directive.
Yes, no, the advance directive can operate because the Supreme Court has said this direction can be given effect to only when the person is terminally ill. That's what the Supreme Court.
I'll give you an example. Supposing you, in the declaration, he says, if I suffer from any form of cancer and it reaches a particular stage, withdraw it. Supposing the man gets afflicted, say, with renal failure. He needs a kidney transplant or dialysis, and then it becomes painful. And then it is not there in this declaration.
The directive can be specific or general.
That's what you're
Yes,
saying.
it can be specific or general. However, it will be acted upon depending upon the board's advice or
That's right.
decision.
Therefore, what you're saying is the starting point and the end is also that the terms, circumstances indicating the disease or the condition with reference to it. I will give you an example. Supposing he refers only to any kind of cancer. He doesn't.
But he has renal failure.
And he gets into renal failure or he gets into some other condition.
Or let's say he gets into a stroke and he's complete in a coma. He may not have cancer, may not have renal failure. Otherwise, the doctor says he's fully except the
Or
brain
he
as a
suffers an accident. If take forget about a disease.
accident.
Supposing he suffers an accident.
There is no directive. In such a situation, there cannot be.
Yeah, and
That cannot-
he's unconscious, indefinitely unconscious.
What happens in the case of an accident that is not covered? It is not a disease.
Lord,
No, can I just read 198.4.1?
Yeah.
Then we will come back, because that may serve some
And
direction.
banana.
Yes.
1 and 2. No, if your lordship is reading the SCC volumes, which at page 131.
Yeah, you have produced a CC so that we are reading this
Okay.
from the
Yes,
paper book.
when and by whom it can be given effect to. In the event the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, the treating physician, when made aware of the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdiction of judicial magistrate first class before acting upon the same. The instruction in the document of the given due weight by the doctors. However, it should be given effect to after being fully satisfied. Only after being fully satisfied that the executor is terminally ill and undergoing prolonged treatment or is surviving on life support and that the illness of the executor is incurable or there is no hope of him or her being cured. These are all the riders added by the court, which I think is a sufficient safeguard.
Just before that, I'll just let me clarify. Directive, number one, it can be general or specific.
Exactly.
In a particular situation, I may give a directive for a particular disease, where under it may be a very painful treatment I have to undergo. Such a situation, I can say, yes, my directive is specific for this particular illness. In such a situation, I do not want to continue the treatment. That can be specific. He can also give a general directive by saying that in any circumstances, if for this one I'm going for a terminal illness, then it can be done. That is a general this one.
Right.
Unless it is a general, for if I give a directive for a particular one, it has to be acted upon only for that.
Exactly.
You can't take it for everything.
That's exactly what we were
Yes,
trying to tell
yes.
you.
It should be like that. That's the only possible
It can only
interpretation.
be that's the only
Yes.
way it can be done.
Yes.
there are diseases, as your lordship pointed out, like cancer, like renal failure, like cerebral hemorrhage, like myocardial infarction, like fatal accident leading to cardiac breach, then neurodegenerative diseases. Problem in the medical science is that the prognosis is different in different individuals. I have seen the most malignant neoplasm in this earth today is meningosarcoma
Yes.
of the brain
Yes.
and neuroblastoma of the brain, where the course of life is just say, 3.4 years. And we have developed advanced techniques where by means of radiotherapy, we can focus the beam at the cellular level. It goes and destroys that only cancerous cells. And people have been surviving for years. So that is why the challenge lies in defining terminal illness. And that is why I was submitting to your lordship as to how terminal illness has been defined differently by different jurisdictions. Because it's a gray area, it's an ongoing area. So what your lordship is saying, that can be illustrating, but that cannot be a law in absolute terms.
Yeah, I can tell you one of my relatives came down with a diagnosis with glioma, a condition in the brain, lesion in the brain. And at one stage of his treatment, the treating doctor said he's got 6 months. Okay, now he is alive for the last 14 or 15 years.
That's what I'm submitting, my lord. One of my patients.
So what they tell you,
So
then, but they say that this is according to our understanding.
that's why I'm submitting.
Doctors are not, gods that, they can really exactly, rather they are perhaps comparable a little bit more to, not exactly like the weatherman. Say that it will snow, perhaps you will have the sun.
No,
If I may
Not
say so,
exactly, I told you.
I said-
Doctors go by a science.
so this is all
There's another thing which I wanted to point you when I saw it. The whole thing is revolving around only allopathy. The entire thing excludes the other forms of medicine. Take, for example, homeopathy.
Yes.
I'm only pointing it out, whatever it is worth. Ayurveda. We don't know. When you say that terminally ill, normally, objectively, we go by it because that is the predominant science. If you are not willing to completely discredit homeopathy, there can be situations where, it might prove.
No, bro, just to answer, bro, answer this,
For a doctor, any qualified doctor, having vast experience, it is very difficult to say that this patient is terminally as much as he will not survive for more than 3 weeks. If he says that as a doctor with 40 years experience, I say it's unethical on his part.
Absolutely.
No doctor
they can say probable, they can say probable.
Because
Exactly what I said.
But there's also one more
you
thing.
treat the individual, not the disease alone. Every individual responds differently to the same disease. So that is why I have chosen to associate myself with
That's
the innovation. That I know certain things which I have learned from my experience and from my insight. And the law evolved from such insight.
That's right.
Now, for example, your lordship raised a very particular question. That somebody meets an accident. Now, accident is not a terminal illness. He may land into terminal illness.
Exactly.
He develops brain hematoma, he develops concussions. Suppose he does not, the nature of accident is not in the nature of brain injury. Now, there was a case 2009, in my compilation, I have quoted 32 pronouncement decisions of different courts. Now, one case from the Australian High Court, there was one guy, Christian Monitor, he was a sports person. And he met a traffic accident. He went into quadriplegia. That means all the four.
All limbs are gone, yes.
He was hardly 40 years old. So for the rest of the life, he was chairborne. Now, he said that I don't want to continue in this condition. I have led an active life. Now, I am chairborne, my wife, my children, they are being a lot of harassment and agony. So my life is miserable, I want to die. So all these questions came before the judges there, that how to say yes or no, because this man is not technically. Then finally the Australian High Court ruled that it is entirely the choice and discretion of the person concerned, whether he should exist in this state of life or not. Okay, he's communicative, he's cognizant, he's fully aware, conscious, and he's doing all his life except moving out of the chair. But he doesn't want to live. So assisted death was allowed, and all he wanted is that I don't want to eat. So I want to die by starvation. No active intervention by any outsider. I will die myself. That is one reported judgment which I have quoted in my
In
complaint.
fact, Jain religion gives you an example of,
Yes.
that you can do that. Many saints have done that. Yes.
In the cases from the Switzerland High Court Supreme Court, there
A
were
larger issue. That's a larger issue. Your religious, spiritual underpinnings will actually come to the fore. Those are areas where we are dealing with it on the plane of law.
so
We are only concerned with that.
No, but that cannot be applied in India. That I don't think this one. It runs against our principles. We can't accept it.
We are here. We are only here actually to consider improving the guidelines, because see,
Improving para 194.
see, basically we should realize how the limitations of the court are also.
Yes.
This is till the law is made by the legislature. Even this has been clarified. Now, the legislature is definitely much more endowed with the multiple talents, skills, sources of knowledge which are required, which
May I just say one thing?
our knowledge, we are neither experts in medicine. We have a smattering of knowledge perhaps in all the fields which we claim, which is mostly actually furnished by the bar.
May I just suggest one thing?
We have to be very careful when you treat.
And I appreciate Lordship's concern that we need not go too deep into this.
And again, understand one more thing.
No, we only need to
Based on
clarify.
this matter on
If it is
March
possible, that's
9,
all. The job is done.
That's why they was it for about 5 years. So even the legislature, they could not come up with the.
No, what happened was it was posted for clarification. That's why they are waiting. Another problem. But to answer just Rastogi's question, please come to my compilation paragraph 361.
I'm going to give a term that while not drawings will be.
Go to volume 2 of application for clarification.
No problem.
Confining to the
Yes.
various difficulties which are being faced by.
That is all that we are
implementing.
I'm just giving a practical difficulty.
Yes.
After this judgment, people went to the judicial magistrate first class to record it. I'm showing the affidavit, advance directive, which we had drafted and given. If your lordship meets with the approval, we can say this is the approved format. They can till the legislature gives a format.
So just let us see what are those things which you want to superimpose.
Yes, page 361 of volume 2. But there are two parts for it. What is, I divided into different stages. One is recording of advance directive, and this is Rastogi pointed out, how, what it should contain, how it should be recorded. In simple terms, what it should contain, how it should be recorded. That's the first one. Then the last stage is how it should be given effect to. So we can divide it into three stages. Contents of the advance directive, method of recording advance directive, and implementation of advance directive.
Implement. These are the three.
Three broad parameters subject to what the Lord.
So what are your suggestions?
Yes, now my suggestion is, as far as the advance directive.
You put it down in writing.
Yes, look, we actually drafted the advance directive in page 361.
So in the same.
So this is the implementation stage. This is the post implementation. The post, please see page 361.
Volume.
Actual advance directive given by lady, which was refused by the magistrate at Mumbai. Yeah. But she's got advance directive of Mrs. So-and-so, Mero. I want, yeah.
Yes, we got it.
Yeah. Residing at so-and-so, Shivaji Park, Mumbai 28. I am an adult of 74 years. I am an adult 74 years of age, of sound mind, and making this declaration of my own free will, that is voluntary and after careful consideration. I have received all information relevant to making this declaration and fully understand it as well as the consequence of declaration. If the time comes, what should we say? If she's 74 today, she is conscious. If the time comes that I can no longer take part in decision making regarding my medical treatment, this declaration will comprise the final expression of my wishes. It is requested that all concerned should take these wishes into account before making any medical decision regarding my life. If at any time I, 1, reach the stage of terminal illness and go into a coma with no reasonable expectation of regaining consciousness, or 2, I have a disease state from which I have no reasonable expectation of recovering with a quality of life that I would deem acceptable.
What is the meaning of that?
Disease has no reason, that is, I will never recover to a normal life, like a vegetative state.
Let's look at the way it is recovering with a quality of life which I would deem acceptable. What is the meaning of that? Who will find it out?
That can be clarified.
Clarified by whom and what stage?
How do you clarify?
No. Can I take it? Is one okay? Is one okay? One practical, is one okay?
Reach the stage of terminal illness.
And go into a coma with no reasonable expectation of regaining consciousness.
That's right.
So it's not just terminal illness leading into a comatose state.
So you take a case of a terminal illness.
Without coma.
Without coma, you'd be.
That AIM form applies. That you don't get.
What you're saying is if you reach a terminal illness state and the pain that you would have to undergo from the stage of entry into the terminal illness and the coma. The whole idea is to avoid that. You have to say that no, I will have to come into coma.
No, but I'll tell you what happened in this case. This is a patient, what she says is, if I'm terminally ill and I go into a coma, then my relatives need not have the agony of taking a decision. It's my wish that if I'm terminally ill, because not advanced directive need not be a standard format.
Does a comma always precede a full stop?
Coma.
Yeah, what we meant was will a full stop always follow a comma? You see what I meant?
I know, I know. The end, yeah, comma is the intermediate stage, come on, grammatically.
What you're saying is, the doctor can tell us, if there is a comma, does it inevitably mean that the full stop is near at hand?
Probably it is a dead.
No, my lord.
No, that's
No,
what
but-
we're trying to tell you.
Yeah.
No, my lord. People have been in coma for years together.
Years together,
My own
does it
previous-
necessarily mean that it's going to be a full stop?
So that is why I submitted the people's estate.
Oh, very nebulous.
The basic dilemma is how to define terminal illness. And that is why the.
Dangerous, if you say.
That's why
going to
medical
coma,
Dangerous.
take it off.
It is
You may
dangerous.
come out of the coma.
Yes. They may come coma.
But no, the point is this, you will have a situation where 100 such patients, only one person has come out of the coma.
We don't.
That's what I'm saying.
At least I don't know.
I'm just saying, no, but the point is this, if you say I've got a right to die with dignity, it is no answer to tell me that, look, in your case, 3 people have come out of this illness. I'll say I'm not interested in those 3 people. I have enough of agony and she's 74 years old. Now, suppose this happens after 90, 95. The person may say that, look, if I go into a situation of terminal illness with no possibility of recovery or recovery with tremendous amount of agony, please don't give me life support system. This is basically on life support systems rather than giving medicines and treatments. 99% is on life support systems. So, my lord, we just give a sample to answer Mr. Rastogi's question. Is there any format? How do you record it? So one is this kind of an affidavit or a declaration.
Yeah.
Yes. But
His right to end life has to be de-linked with the terminal illness. Otherwise, that advance directive will become meaningless. Because how one will know that this particular person is terminally ill? Even the doctor will be hesitant to certify that he will die within 3 months or 6 months. And if they do it, that is a premature and wrong decision. That is contrary to Hippocratic oath. So the doctors will find it very difficult to certify. Doctor will just shut. So it will not be implemented. So the basic global paradigm means that a person has got to right to die. Once he find a right, the life has become very, very burdensome, cumbersome, regardless of terminal illness. So that is the first thing which has to be modified. In their lordship judgment, they have written that advanced directive will be.
Doctor, we will conclude hearing him. Otherwise, what will happen is I can hear you.
Okay.
That is better.
Fine.
yes. But now I'm at the first stage is the contents of the advance directive. Now, this is the contents. These are the possible contents. Now, your lordship has to decide how this is going to be recorded. This is just a sample. This is not the end all. Lordship can tweak it, modify it, because like para 198.4.
Very short and brief. More you elaborate, more the confusion,
I agree with you.
more the problem.
Yes. Vegetative state, this,
That even what is making
possibly, yes.
it should be very brief. His wishes must be disclosed in the declaration form. Leave the rest for the medical board to examine as to what conditions are required, what conditions are to make his safety more.
I think so. But as the lordship pointed out, the more you put, I deem acceptable, vegetative state, ifs and buts, then become in. But this Ames form is being followed from time to time. The lordship sees that
This is page
page 11.
11.
I thought that could be the basic contents of advanced directive can be what Ames is following. And that can be recorded. So basically point is terminal illness. Remember, there should be a balance between that man's wishes and also a potential misuse. As long as the man is conscious and says, I don't want it, we will respect that. And as Lordship rightly put it, people say, look, there is no point, just take him home, let him be happy. That can, please see page 11. And that's why we have given our prayers multiple options. So if your Lordship sees that today, if 194 can be modified to say that an advanced directive is having multiple paragraphs of 3-4 pages, Lordship can just have a 1-2 paragraph advanced directive saying that the patient, I'll put it this way, advanced directive can be given a person for withholding life support in the event of terminal illness, where the chances of his recovery are deemed to be remote by a panel of doctors. Will that be all right?
Yeah.
That's so. So please see Ames. Patient's wishes for withholding life support. I with so-and-so admitted aims have a critical terminal illness where disease modifying options are no more applicable. That's what it's got the aims. Page 11 of this Bible book.
Oh, yes.
That may give a good working model.
Page 11, yes.
Page 11. Yeah, I spoke to the doctor last evening. They say they take this form. Patient's wishes for withholding life support. I with UIHD summons admitted at AIMS New Delhi have a critical terminal illness where disease modifying options are no more applicable. Lordship, with a good expression. Disease modifying options are no more applicable. I understand my general health is poor. I also understand the futility of life supportive measures such as endotracheal intubation, cardiopulmonary resuscitation, which will cause suffering without any reasonable benefit. My goal of care will be symptom relief, comfort measures, and quality of life. I hereby request you to allow natural death in the event of cardiopulmonary arrest, no external chest compressions, no intubations, no chemical or electrical cardioversion. I understand that signing this document would not deprive me of required medical and nursing care, pain and system relief modalities, and nursing care as appropriate, with the highest priority to maintain dignity of life. I say I'm making the declaration for the free will and there is no coercion.
This actually is very simply done.
Being followed.
And I think this, and particularly the patient's goal, my goal of care would be
Symptom
symptom relief,
Comfort.
comfort measure, and quality of life. Like the example of the grandmother that you gave, I've led a full life. My children, grandchildren are settled. I don't look forward for anything more from life. And if I am to come to a state of terminal illness, I want to die in peace. So dying in peace should be a wish which...
Or we'll say die with dignity.
Dying with dignity, that's right. In fact, Article 21 also, when we talk about, this query came from the court. Article 21 also talks about life with dignity. It's not just, animal life, which is what the interpreters have said.
Can you, Your Lordship, then no Lordship, go back to 194. The advance directive, if I may suggest for Your Lordship's consideration, advance directive can be made by a person indicating that he wishes withdrawal of life support, to use AIMS language, where he has had a critical / terminal illness where disease modifying options are no more applicable.
Yeah.
It's very broadly worded, critical terminal illness where disease modifying options are no more applicable. So Your Lordship takes care of the medical science. So at that stage, are no more applicable. So this will be the examined by the medical board. Is there any options are available? That goes to a review board, which I'm coming to later when I come to implement it. So one question is, this can be a format of a declaration where it can be simple that advance directive is the right of a person to declare that if he reaches a stage of critical or terminal illness where disease modifying options are no more applicable.
Which part of this declaration are you saying it should be part of the
advance directive?
No, this is in respect of somebody who is actually going to the hospital.
No, he's admitted as patient. He's got a number. Yeah.
So this may not be apposite when you are making it in advance.
Yes.
I'm making it that I am at 25 years.
No.
40 years. I have nothing. I have not gone to any hospital. So which part of this declaration would fit in with this advance declaration?
Yeah, I would say.
Which part? You just tell us.
Yes, I'm saying the first paragraph.
Which one?
I'm first paragraph.
Yeah.
That can I suggest this way, madam? I'm talking advance directive, say a person who's 50 years old or a 60-year-old person who wants to make a will.
Yeah, he's perfectly healthy.
He's perfectly healthy.
Yeah.
He makes a will and makes an advance directive. So what could he do? What's my suggestion?
What should it convey?
I would suggest that he will say, I am making this advance directive, which will enable the doctors or the caregivers to withdraw life support in the event of my reaching a critical / terminal illness where there is no hope of recovery or where there is no hope, where disease modifying options are no more applicable. And yeah, if you can recover, remove that my general health is poor can be deleted.
Yeah.
This is patient's wishes. Patient's wishes.
Who's already come to hospital, who's already got in the last
Somebody who's gone.
What just Joseph is asking is, suppose the person is 60, 65. Most people will make a will after they're 60, 65. They want to make a will now. They got assets. They want to settle the properties and so on and so forth.
Especially this kind of a thing, we will have to ensure that this is not made under threat or coercion, etc.
That's the second part. How to record record. This is
And the evidence is also there.
Yes, yes, always, everything. Like a will also, but I can make a will. That's why you got testamentary jurisdiction. They say will is made under coercion. You're not under medical thing. He's giving the property to that son who was looking after him only. He influenced him. So all those problems we've got, at least in the Madras High Court, we've got original testamentary jurisdiction. So it's there.
He is giving, see, this directive, adverse directive. At a stage when he was healthy.
Yes.
Which one?
No.
Exactly. No,
Therefore, under what circumstances he's making it?
No, it could not
That's
be.
the point we look into.
It could also be, suppose a person gets afflicted with cancer. He hopes for the best, but he now says, all right, this is a possibility. This is an eventuality I'm going to face. Or suppose his case has got renal failure and it is galloping. He knows that this is an eventuality. There is a miracle that I may survive. So he may make it when he's healthy. He may make it at the very last stage. He may make it in between. The most important thing is he should be fully conscious of what he's doing.
These contingencies were actually envisaged under 198 for 1 and 2.
Yes.
Politics is there.
No, the question what Dr. Kishore pointed out is the High Court, the Supreme Court says that you will implement this when there is no hope of any cure. That I'll come to the implementation part. Now, Murad, I'm just going to the stage where what should an advance directive contain till the legislature declares the format. Because today doctors have got a practical problem. Nobody is able to take a decision. They don't want to take a decision. They're afraid. Suppose something happens. So now if there is a Article 142 direction or Supreme Court direction, this is if an advance directive is in this format, it's a valid directive.
So, Mr. Datar, we
Yes.
have to tweak it a bit because this is applicable for a patient who is already admitted. So we have to say that in the event of my being admitted with these conditions which are mentioned
Yes,
there.
that's a good idea.
We have to
Yes,
start off
yes.
by saying in the event, because somebody 40-year-old, 50-year-old, somebody has to, he's not admitted. Yeah, he's playing his tennis and his whatever he's doing,
Or an accident.
or an accident kind of a thing. So
So there's also a distinction between a critical illness and a terminal illness.
Yes.
Here you have actually brought in both. See, how would you define critical illness? There are so many critical illness.
The doctor.
No, we are telling you.
No, can we'll restrict to terminal.
Ah,
We'll restrict to terminal. Why not? Let's not get into critical. Critical can be what is critical, what is
we
not
don't know what is
critical.
critical.
It's subjective.
There are so many people who come out of so-called critical conditions.
There's a big theory of mind over sheer willpower you can.
Thought word critical has been consciously added here.
what is critical for a
Because
normal man? What is critical for a normal man? Is not critical for Michael Schumacher.
That means
We are saying what is critical for an ordinary person of normal wealth. What is critical for a,
this word
Is it critical added for a?
critical has been consciously added in these judges.
no, what we are saying is the element, what is critical for another person is not critical for Michael Schumacher.
Yes.
We are talking about somebody of that capability.
So that criticality of illness is individual oriented. A person may find himself in a critical
That's
illness,
right.
but may not find in the
That's
critical.
right.
Yes, therefore,
These are the real.
yes, yes.
No, just page 46, 47. Manipal Hospital has given.
unnecessary.
So these,
This country has more than 130 crores of people.
there are capital wide reports. Critical
And
illness.
tell us one thing. We have a human donation or organ donation.
Correct.
Government has tried its level best to promote, but no sane person is coming forward to.
No, I'm sorry, but there are a lot of people now giving eyes.
Yes, but very.
They got harvesting the.
Looking to the total
Oh,
population.
yes, it's only the metros. It's only many metros.
Correct. We're talking about literate class people, elite class people. Nobody can put somebody for himself. Oh, something is going wrong to me and I'm going to do it. Very difficult to say. Now we're talking about directives, advanced directives. Advanced directives can be at any point of time without age barrier. But you will find hardly people, hardly, not even 0.1%, who would be coming forward to give an advanced directive at the age of 45 or 55. So, as long as I am healthy. Mostly people, when coming to a hospital in a critical state of health, with the treatment, they know that what is going to happen with me. They may come forward, all right, now I don't want any kind of infusion to me. So this form which you have just read over to us is more workable. Keeping the riders over it, the medical board to examine, so that so nobody can misuse the kind of a declaration being sought from the patient, who might not be in a position, may not be in a position. So we want to know from you what kind of a safeguard which you can put while this form is being filled by a patient admitting to a hospital, so that nobody can misuse this proposition. So when advanced directives are concerned, like in 98.3, this magistrate and all theory, this is cumbersome. You can simplify so that any person who willingly want to have advanced directives can go through the mechanism by filling the form of 98.2. And 98.3 is a core barrier to put how the mechanism to work. Give us a simplification of 98.3.
Manoj, can I suggest?
And 98.4 follow with 98.1.
Manoj, can I suggest one thing, Manoj? Many of us have made wills, and we make the will in the presence of two witnesses. Now, one option is like an advance directive, also like what called living will. So it's also part and parcel of the will, because many of us say that, look, I will say that I don't want to sing. And we also say that after me, I don't want to elaborate religious ceremonies. So many things we put in the will. Now, just as in a will, the safeguard is why you have two witnesses, to show that the person, the testator, was in a full faculty, there was no coercion. So like that, if we can have a saying that I don't have a magistrate, just as if I make a will in the presence of two witnesses, why can't I make an advance directive in the face of two witnesses, which anyway is not going to be acted upon unless there is one board and second board. There are two boards which are going to reconfirm for taking off the treatment.
But here, see,
Yeah.
the one independent witness should be there, then of course.
Or doctor can be
the
there.
Magistrate also, and they will have to record their satisfaction.
But my request is, let's not get the magistrate into the picture. My humble suggestion is, if I can today make a will, where I can also say that, look, many people say that after my death, he's
There
doing
is
something.
something, understand one thing,
Yes.
will of course is the property, etc. Now here's the very life,
No, I'm saying like a will. What Justice Rastogi says, how do you record it? Do you go to a magistrate? Do you video record it? Do you go to you go to a notary public? I'm just giving example. Where do you go? So, pardon me? Yes. One option was to go to a notary public, or I'm just suggesting, can I put it this way? Advance directive can be recorded in the presence of an independent witness, a non-relative, and a doctor. So those two can be there. It'll be simple.
Yeah, but this advance directive, as you call it,
Yeah.
in what area will it actually have operation? You see, if I am healthy, okay, then I become sick, then I reach a particular stage, I can either make up my mind myself, I don't want the treatment. Nobody can compel me to get the treatment. Right. It applies perhaps only in that narrow area where he becomes so ill, that terminally ill, that he is not in a position to say, please stop the treatment, I don't want it. I think this directive will have use only in that area.
No, but can I say
Specific.
No, can I just,
Otherwise, he's a man of free choice. He can always say, I don't want this treatment.
no, Lordship is right.
It's only when he goes into a vegetative state or a state of coma, as he calls it, then he can't take the call.
Can I put it?
Somebody else will have to take the call.
Correct.
Otherwise, the choice is always there. He can say, I don't want it.
No, I'll put
What
it
is
this.
the real utility of this
No,
advance?
I'll tell Lordship.
Lordship is that. Sir.
Yes. What your Lordship is saying is, if I am a person who becomes ill, if say Mr. X becomes ill, then he goes to hospital, he takes a call.
He may even not go to the
Yes.
hospital.
He may not go to hospital.
There are so many people in our country dying that way.
Who don't want.
Who
No,
don't want? I know
No,
that the
I-
rural area particularly, they say, I don't want, it's okay, he's had lived in the doctor is saying, I don't want it, fine. Nobody can compel him.
but I put it
Not a
this way.
case of,
No,
306.
correct.
Where you're committing or abetting and all that, nothing is there.
There are multiple,
Just said, I don't want it.
multiple
No, can I say
circumstances here, sometimes,
question.
sometimes,
Where advance directive will come, sorry.
but just one, such as you pointed out, such circumstances in the rural areas may be due to various factors. Because of number one, maybe financial condition, he may say that I can't afford to go for this kind of treatment, so let me die because I have had a good life.
Have you thought of a legislation in this field? 5 years.
That's, I have to, I'll come back by.
But we are giving a bill also.
End of-
This will be draft
Yes.
bill.
Is
So
it
that was-
not, is it not essentially a legislative function?
It's a legislative function. It's a legislative
Then
function.
why
without
don't
a-
you, if the legislature has applied its mind and you are representing this
Correct.
government,
Yeah.
why don't you,
No, what has been done, this one before end of these proceedings, definitely I'll come back to it. Because that was suggested at the time of the judgment also. They
Legislature
said,
will come when it comes.
But then what you're saying.
Well, the answer is, no, this will come in a case where a person doesn't become ill and go to hospital, there he can fill this AIMS form, there's no problem.
No problem.
A person, it could be happen that a person signs at the age of 60, 65, he suffers a stroke, he goes into a coma.
So that is the
Yeah,
area.
that is a normal area where,
The only area.
yes, perhaps.
Right. Why do you say any other area? That is the only area. Otherwise, it is always a matter of choice. He can always.
That's why in some countries, there is a minimum age requirement is there. You just go through para 196.
No, I will.
196
Yes.
of the very
Correct, correct.
the British Columbia, etc. No, minimum age requirement. Why should a person at the age of 30 should be living 30 years? I may become like this.
So 60 years.
And therefore, a minimum age requirement it is there in certain countries.
Washington put 60 years, only people above 60 years should make it.
This situation was also very much discussed in para 196.
So basically the magistrate,
Even for writing this advance, sir.
Brushing itself is a difficult. I can look at your eyes.
compartmentalize these issues. The first one is the deponent or the proponent. That is his wish he is going to express, number one. First part, he can express when he is in a healthy state of affairs or healthy condition, he can do it. Or when he anticipates some kind of ailment which may end up in terminal illness. That is the second one. The second one is when it has to be executed. That depends upon the doctor's call, the medical board. That is the second step. The most important is what are the conditions will have to be fulfilled, what are the safeguards will have to be taken for the purpose of recording these kind of the directives. That will be most crucial aspect. When he expresses his desire or the issues a directions, what kind of safeguards will have to be like a dying declaration when we believe or when we accept it, what should be done in such a situation? Similarly here, because it has to be acted upon later. So therefore, I think in the present situation, we have to first focus on what are the directives will have to be procedurally protected.
First of all, we will have to go through the already laid out directions.
Correct,
guidelines,
correct.
And thereafter, whether any clarification is required or not.
Absolute.
But you are
Yeah, the main clarification is this multiple going to the judicial magistrate, multiple votes, that is the point. that we
Why
eliminate.
don't you concentrate on that?
Exactly. So that we are confident.
Otherwise, let us not tweak, what has been laid down as to the contents of this advance declaration. Because the content, there are two.
Can I do one thing? Bharat?
Content will just tell you one thing.
Yes.
A person can say, they refer to the diseases which he he dreads, and then say, then this happens that if I go into a sort of vegetative condition or a terminal illness, and then it should not be given, treatment need not be given, it shall not be given. Or he can say the choice of conditions which may be common to, where you are ending life, coming very close to life, which is going to be painful and where he will have no control because he slipped into a coma.
Bharat, can I just one?
Short of the period, because if he is not in a coma, we are telling you again and again,
Yes.
the kind of people who are going to make use of this facility are persons who are capable of taking care of themselves. They'll say, I don't want it. It's end of it.
They'll fill the AIMS form.
Huh?
They'll fill the AIMS form.
Fill the end form. Why do you need this? For whom? For whom is it?
No, the point is, as your lordship rightly put it, this is to aid people who have lost their decision-making capacity.
Exactly.
So they have taken because
That is where
as Chancellor Ravi Kumar's question, FY40. I'm told that Mr. President Obama and his wife also signed the directive when they're 44 years old.
That's right.
That's a different matter, but that doesn't matter. But
See, we don't have to
Follow
we don't have to follow the West in all that we do.
can I do
There
one
are
thing?
ideas, modern ideas. There are ideas swirling around the whole of the world. What is good, we will take it.
But can I suggest one thing?
Okay.
I will take para 194 put it on the left-hand column, and right-hand column, I'll say which right needs to be modified. So I'll give your lordship a complete chart.
Well, let's do it.
This is what 194.
Let us do it right now. This has come up on 2-3 occasions.
Yes.
Let's close it. Otherwise, again, we can't be having
Yes.
a constitution
Yes.
debate again all over again.
Yes.
So then get down to it.
Yeah.
And basically, you should be into the checking mechanism. That is
Yeah.
where perhaps you have a problem.
Yes.
This first a medical board, then it goes to the collector. Collector constitutes a medical board consisting of the chief medical officer. He again, they also counter certify it.
But can I
That is
suggest?
the area I think you have a problem.
Yes, yes.
Tahsildar. That process perhaps it should be.
I'm going to suggest on my part, Lord, that simple, it can be declared before two witnesses, one independent witness, and it can be before a doctor.
That be as good or bad as a will.
Exactly. Keep it at that. Keep it at that. Because otherwise, there's no amount of safeguard is going to be there. How does the magistrate know, Lord? And first of all, magistrate has to come. Nobody has the time. Now,
It can also be part of a will also.
it can be part of
Part of a will
It
also.
can be part of a will also. But if the will has an advance directive, then one witness should be a doctor, is my humble suggestion.
So there is a problem with the will, I'll tell you. I make a will. Okay. I leave it somewhere. Okay. Now, none of my relatives know about the will. The will ordinarily takes effect only on the death.
But normally we hand it over to the executor. Normally we put it in a seal cover and give to the executor.
Therefore, we have to say that.
Yes.
Can you say simply if you say will,
No.
it is capable of being embraced in various circumstances. Supposing I make a will and I leave it, I put it in my almirah, nobody knows about it. How will they give effect to it?
Correct.
Segregate.
If you want to make it a will, if you want to make it effective, it should be known. Secondly, it should be known also to the close relatives. So it is better that it should not be in a will. Why we tell you?
Separate advance directive.
Segregate. Segregate.
The contents of a will, you will be alienating at least some of your. So it should be a separate document, not.
I fully agree. Let it be a separate advance directive. Exactly. And what it
Should be known to the relatives so that it will be given effective. If you want it to be given effective, I am not particularly keen that personally. But then that if it is to be given effective, it should be known beforehand. It should be made with the full consciousness. That's all. And then give effect to it. I mean, if you want to die in peace, as you call it, so be it. Let us not make it very cumbersome.
Yes. Yes. Absolutely.
Correct?
So, Lord, one thing, I can do it right now, or would your lordship?
Right now, let's close it. As is, what I give the
No, but that's it. Should be that.
it should be. Our brother is saying it. Perhaps by tomorrow we
I'm
can
about
go
to
to
say
the
that.
other matters. So you will come better.
I'll just take 194 and tell your lordship. Now, I have 2 points so that I do my homework. One is, as far as advance directive is concerned, 194.1 says, I will go by the same format, what it should contain. This question which your lordship has got, just to take 2 minutes so that we don't don't.
198, not 194.
No, no,
198.
no, please start with 198, yes, yes.
98.
Yes. Now, my lord, just, the lordship just help me, I'll just then, so that tomorrow time can be much easier. Who can execute the advance directive and how? Lord, I don't think we should put any age limit. We leave it to the person unless your lordship wants to say it should be done by a person above 60 years. And your lordship may just think about it. Whether you want me to put an age limit or put 40 years or 50 years. Whatever your lordship says.
I don't think there should be age limit as long as you are a major. Because this can happen at any stage.
We only said that that was considered earlier. So, para 196, that was there.
One second, para 196.
Record note of the fact that in some countries, this was one of the criteria.
Yes. Lordship, yes. Lord, who can execute? And I take a lordship suggestion, it will not be part of the will.
I don't know the medical science. You see the branch of psychiatry. What they say is that the human brain grows up to perhaps the age of 10, 11, physically. But the personality development, you stabilize somewhere around the age of 25. Got something
Yes,
to do
yes,
with
yes.
criminality.
Yes.
It's an area which is emerging.
Yes.
If juveniles 18, but beyond that, there is an age up to 25 when your character, personality development continues, evolves, which is why you have a lot of crimes between the age 18 and 25, where you have to view it perhaps differently. It's a matter for the future. That's what they say.
No, I just take it that who can execute the advance directive? Any person of a major in his right mind.
Can we make it 25? I'm just making a suggestion.
Yes.
I don't know whether what my brothers will.
No, I was thinking better to make it above 50, bro. That's my suggestion.
50, actually in the Indian context,
Yes.
where the family also, an 18-year-old person saying that this is what,
He may not
his
be-
parents, his uncles, his aunts, everybody is there, So perhaps a more mature age.
30 years.
50 might be a better
I
idea
was suggesting 50, but better than 50 or 60.
and not part of the will. I was not correct there in suggesting
For
that.
certain ailments, I don't think we have to wait till 50. For certain ailments, it may, somebody, no,
Accident can happen much earlier.
not even accident. Some ailments, it might be diagnosed even at the 30s or 40s. At least some 40 would be little better, I think.
On my side, they are saying let there not be age limit. Let there not be an age limit. It's up to a person.
No,
What's the-
my respectful submission is that it will not be desirable and wise to fix any age limit
We'll leave it to them.
executing or making advance directive.
18 years is option.
Yes.
No age limit.
No, major. He has to be major.
He has to be,
Yes.
he should be a major. Above 18 at any age.
Is
There
this,
is no jurisdiction of the world this age limit has been given, except for minors. So that will not be fair.
Otherwise, the next problem will come that he was not adult that time. So there should be a separate inquiry.
So we don't.
Leave it. Like in juvenile, in our juvenile
So
system going on.
should not be.
After 30 years,
So there's no age limit.
after 30 years, we are asking for an inquiry to
Correct.
decide whether you are juvenile on that day or not.
All right.
So, but we'll say no age limit, point number one. Point number two, it is not part of the,
Then,
it has to be separate from a will.
one more thing.
Sorry.
Then please read 198.1.1.
One,
198.1.1.
Yes, ma'am.
Already it is there. Advance directive can be executed only by an adult. So if we say
Fine.
that there is no age limit, that means it's as good as
It's taken care
modifying
of.
this.
It's taken care of.
198 or 1 is already
No,
there.
no, your lordship suggested above 60, so that's why I mentioned.
Mr. Tata,
Yes.
198.1 is clear, 198.
Point two is clear, yes,
Come to 198.3.
also clear.
Here, no, 198.3 where the recording of this is magistrate and all business goes on.
Yes.
This you suggest what modification according to required.
We just need a little presence of two witnesses.
Two witnesses, independent.
Two independent witnesses and one doctor.
What doctor who? Doctor
I'm
Neil.
just suggesting.
No, which doctor? What standard?
So if the family doctor can say, or two independent witnesses can be there, because ultimately it's going to go before the board.
That's correct.
So that safeguard is always there. It's not that since I say so, I'm going to immediately allow to die. There's a primary board, there's a review board, there's a 6-step process in there.
Riders are there.
Yes, yes. So safeguard will, so I'll do one thing, but simply make it signed for two witnesses. It should be separate from a will. And in the will, I can indicate that I also made an advance directive. And as Justice Joseph pointed out, it should be declared, known that an advance directive has been made and it should be known to the person. How do we make it known is another question.
One is, digital is there, that is being recorded digitally.
Any data bank is there of advance directives?
In my compilation from page 1 to 6, I have answered all these questions. I made a table in my compilation from page 1 to 6. Seriatim I have answered. What is the problem with the judgment and how should be addressed? Each and everything that has been discussed here, I have written.
But I'll do one thing, I'll sit with him and we'll finally debate tomorrow.
Page 1 to 6 of my compilation. I have made a table about the magistrate, about the high court, about the district judge and everything.
That's right.
It's a ready-made answer for all those naughty areas. What else?
There is one thing, 198.3.
Now,
198.3, it says how it should be recorded and preserved. It is already there.
so that
What is the clarification which you want in that?
198.3 is the main problem area.
That is why
just
it is already there. How it should be recorded and preserved. It is already there, laid down. And what is the clarification? Because it's only a clarification we need. You are not rewriting this. So already the constable laid down how it should be recorded, how it should be preserved. So what is the difficulty in that? And why you are seeking a clarification? And if so, in what manner?
No, because what happened after the directives came, It was found very, very difficult to go to judicial magistrate first class.
That is why.
Yes.
So already 198.3 is there, therefore you will have to say what are the difficulties being experienced
Number one,
and in what manner the modifications are required.
and one more thing, even if 190 is recorded, it will not be.
Which paragraph?
How it is to be placed.
Reserved in the register to the district court.
How it should be recorded, first thing. How it should be preserved. It is already there.
I know that, but that's why we said
Therefore,
also the most.
What were the difficulties experienced while following these directives? That should be there because already directives were there. So you will have to come up with the difficulties, practical difficulties experienced, actually experienced.
No, there is no actual experience because we have gone to magistrate, they refused to record it. On page 15, PC page 15.
That one question, because it is a person actually has to be, a magistrate has to be deputed for that particular purpose by a sessions judge going by the decision.
But it's not possible. Please see page 15 that Mrs. Mehta went, the magistrate was not available. He refused to come. He was held up with bail applications.
Legal service.
And what is the purpose of assigning for a magistrate? Ultimately, if the primary board and review board is going to decide whether to take away my medical care, what purpose is served by going to a first class magistrate?
What about an audio video recording?
Yes, it can be. That's one thing I suggest. It can be audio video recorded, it has to be preserved. Now the point is, where do you preserve it? Where do you preserve it? Is there some data bank? Say, is any hospital will have a wing or a court will have a wing? We don't know. Like for example, will, you can register a will. Possibility of registering the will.
Why we are
You go to register.
questioning
Sorry.
is, so long as this 198.3 is there, it's not a review. You are not going to review everything.
No,
And
this
therefore
is for
you will have-
modification. This is for modification.
that is why, so understand that and then come up with.
Yes, yes, yes. But that's why the bench also was thinking that this is unworkable because if it's not, the point is, the whole this is ultimately what are we trying to do? We are trying to say that when a person is in a vegetative state and he's not able to decide, please allow him to spare the relatives the agony of taking a decision. It's not for the person who's anyway in this thing.
No, we are now dealing with advance.
No, I'm dealing advanced directive. What
Advance directive is something that is being made at the stage when he was.
Nataraj, this preserving is important, so
Yes,
that everybody gets to know,
Correct.
critical person,
Correct.
the family members. So can we not have a digitally recorded thing
That's right.
and then a portal
Yes,
which is applicable all throughout
Correct.
the country,
correct.
where it can be preserved. So anybody who gets admitted, now every person say
Correct.
Aadhaar card or whatever connection,
Correct.
we suppose that is there, that immediately
That's
when you
right.
get into the hospital, you have to give your identity
Correct.
number. So through the Aadhaar card, all right, there is an advance
Yes.
medical directive of the declaration of this person.
Correct, correct.
Something like that.
Like a large, practice for a large country like India, where do you record it?
No, so therefore, should the government not come out with a portal where this has to be recorded?
So, come to 198.3, everything has been taken care of minus this magistrate business.
Yes, yes.
Minus magistrate's business,
Yes.
digital format, where to be preserved, what is the agency to work, everything is there.
No.
Minus magistrate business and the satisfaction.
No,
Everything goes in order.
handing out to a municipal corporation, all that becomes uncomfortable.
But the 198.3.1
Yes.
document is signed by the executive in the presence of two attesting witnesses,
All right.
preferably independent, no problem. Countersigned by the magistrate, we can substitute for magistrate what can be the substitution. 3.2 goes minus this substitution of JMFC. Satisfaction is recorded and full understanding goes and everything goes in order. Nothing required. Come to 3.3. It has to be preserved in addition to keeping in the digital format. 0.3. Now, how it is to be preserved, that is the mechanism the government has to find out.
Portal,
Portal, whatever the mechanisms. 3.98, 3.3, now 4. Only minus JMFC business. So you have to substitute in minus JMFC. What could be a substitution which make the system more workable, effective, and to the satisfaction of the executor?
Either before the registrar or before the notary public.
Registrar of whom?
It says, it has to be signed before the registry of the district court. So it's going to the district court, one is like a will be registered, a will before the registrar.
Yes, sir.
Or we sign before notary public. But we are making it as easy as possible.
That's correct.
Because I'm only worried.
But keeping the safeguard also.
Correct, and I'm submitting that the safeguard is in the primary board and the review board. Here-
You may explore the, possibility of using the legal service authority that has a deep reach. And usually a judicial officer
No, where I'm coming
is
from.
the
is-
member
Where
secretary.
I'm coming from is to record it in a particular place, keeping this is a big problem. I'm saying if it's an advance directive signed before witnesses, let it be there. So what happens is when you go to the doctor, you can say, I've got an advance directive already there. Then they say, okay, since it's advance directive, then there is no need to get the consent of
The
the,
authenticity of that, like we.
yes. That's the only problem.
That is the-
That's the only problem.
That is
We're
challenge.
only worried about that. Now, the point is, one is to make it, either file it before the registrar or have some kind of data bank, but how do you do in a large country like India?
The
large
large country, we.
Government of India is there, they can.
We can tell you one thing, this large country like India, when you say, this is going to affect a very, very, very minuscule percentage of the population. It is not something which is going to be made use of by the very, very large predominant majority of the Indians. This is going to affect a very small percentage.
At the beginning.
At the very beginning and.
No, it may pick up also.
Yeah. You don't know whether it's that's something which should engage the legislature.
Or can I say this one thing?
Yeah.
Many of us are registered with some hospital. We generally get registered with Apollo hospital or this hospital or that hospital. We got a number because when you go for a treatment, first thing they ask is, have you been registered? Because before you enter a hospital.
Correct.
So one option is to say that whichever hospital I'm under treatment, that hospital can simply keep that thing as a record. That's all. That's why I said above 60, because if I'm 30, how can the hospital keep the record for the next 40, 50 years? One advantage of keeping it after the age of 60 is it reduces the recording.
Might require some kind of permanent recording.
Yeah.
That possibly.
Yes.
The larger,
Government of
We have to
India
work,
can-
yes, we have to work out at the same time, creating
the larger population is below 35.
a portal that may create
But I'm
kind of,
afraid
one more issue may arise for.
recording. There's no repository. No country there's a recording.
All these directives, with no jurisdiction I have come across.
It can begin from this jurisdiction.
These advanced directives are not preserved by any governmental or executive authority. They remain with the patient and their family members. Single case of abuse has been reported.
If it is later on discovered that advance directive was a counterfeit or a fake one, then who will take responsibility of that?
The whole thing is the approach. So we go there because there could be one
Because
possibility.
for will, the testamentary jurisdiction,
Yes.
will has to be specifically proved before the court before being
Yes.
given effect.
If there is a contest.
No, otherwise also
Also,
court.
we have to prove it.
No. I'm saying suppose.
Without a contest also, you have
No,
to prove.
suppose the bill is there and the family agrees to that.
No,
contest of
it
bill.
has to be proved. It has to be proved.
No,
in
if I
a-
want to get a probate or letter of administration.
No, even in any proceeding, it has to be proved. under-
Correct. If there is a litigation.
Madras
If there's a
President.
litigation.
Yes. No, we have, Lordship knows about Madras, we have got this testamentary jurisdiction in the High Court. as a
Yes,
separate-
where a will before being given
Yes,
effect
yes,
has to be.
And if the will is contested, it becomes a TOS, becomes a transferred origin suit.
Otherwise uncontested, they give the,
It's a OP, there's a petition in the probate for the letter of administration.
it has to go through the judicial process.
No, I'll keep in mind this concern, we just,
In
tomorrow
this
we'll.
situation, this
Instead of,
situation,
instead of the magistrate, because the magistrate, first of all, he has got so many functions.
Yes, impossible.
So a gazetted officer, but not, enumerate a few of them. So that widen the basis instead of magistrate. Because otherwise, to trouble the magistrate for this.
this twofold, in this situation, we should have sufficient safeguard. That's most important in the matter.
That's why the
Yes,
court went
number
out
one.
to.
At the same time, there may be one more issue which may crop up for this one consideration would be. Some directions are, it must be made known to that person, this officer and all those things. If my directive, if it is to be made known to somebody, that may offend my right of privacy also. That also has to be taken care. It's one of the aspects which may crop up for consideration. Definitely that will trouble. Suppose I am suffering from a particular ailment, which I do not want that to be made known to others. By implementing this direction as it is, my ailment will be made known to everyone.
No, I don't.
Yes, that problem will, no, tomorrow I'll come up with the same theory. That may be my wish. I do not want this, my ailment to be made known to everyone. So we have to protect that as well.
Today you are not.
Come out only.
So therefore we have to confine to the,
1.190.3.
yes,
How can we substitute in reference to the JMFC business?
yes.
And
That's
safeguard
right.
the interest of the
Correct.
individual?
Yes.
The right to privacy has to be given its freedom.
Correct.
No, one more thing. As far as 198.4 is concerned,
Yes.
This double board thing is a little problematic.
no,
Why is you have to go to two boards?
no.
That you have no problem.
No, same one. So now the homework is to see what can be done to make 198.3 workable. Other point is 198.4, which was also deliberated in great detail with the health secretary, AIMS doctors and other people. Kindly, this is what we're suggesting. If the Lordship approves this, then we can work on this and give a suggestion.
Yes,
Now, this is where an advanced directive exists.
yes.
Now, Lordship is to visualize a person who has come to hospital. There is an advanced directive. He is terminally ill. Then what happens? I just read not step 1. May I read now?
Yes.
Treating team of a patient to confirm when that the patient lacks decision-making capacity in relation to decisions about medical treatment. Step 2. So, Lord, this is called the first primary board. Lordship will call, we have called it step 1 as a primary board. Step 2, primary board. Primary board to confirm. Oh, sorry. Step 1 is the doctors treating him. That goes to a primary board. Primary board to confirm that initiating, escalating, or continuing life-sustaining treatment would not be beneficial to the patient. Primary board to consist of the treating team of the patient and a member of the hospital ethics committee.
Does hospitals, all hospitals?
No, large hospitals have, but we have put wherever applicable. So Lordship will just put a comma here that wherever I'll add it wherever applicable, because it could happen in a smaller town. The hospital may not have an ethics committee.
Yes.
Assessment of the primary board to be ratified by a review board.
What is the review board?
Yes, because before they decide to, because this court also has suggested a second, why we did this was, the Supreme Court said there should be a multi-tier check. So what is a multi-tier check? Instead of going to the collector, then the judicial magistrate confirming, then what the Supreme Court says is, the collector will form a separate board.
That's what you're saying.
Yes.
Is that feasible?
No, so we said, let this, we put a simple review board. Just imagine a person goes to, let's say, AIMS, or goes to Apollo Hospital or some hospital. His doctors say that, look, yes,
Of the judgment.
yes. If you were to make workable, in this form, it will not be workable. Yes. Our Lordship will kindly see. Step 3.
Becomes a review, but in modulate.
Modification. I'm not saying because if you make order 47 rule 1 applies.
The public investigation, basically, one suggestion which I have is, one way of doing it is because in the primary board, you can always include the chief medical officer. So the chief medical officer is brought in the second review board, so as to give some kind of an authority.
Sorry, there's a doctor here. What happens, I'm told that this decision may require quickness. So they just want one independent director and somebody from the ethics committee. The CMO may not always be available. That's another problem. Then
What you're trying to tell you is that if the CMO is made a party,
CMO or a person delegated by him.
Huh?
CMO or a doctor delegated.
Somebody from the government department. The whole idea is that.
No, it could be, let's say in Madras, say it's a large private hospital.
That's right. But somebody must be either under the authority of the CMO.
Or the head of the hospital.
Either the CMO.
Or the hospital's director.
Correct. If he is part of this review board, then there need not be a further review board.
No, is your Lordship thinking of only one primary board without a second review board?
That's what I have in mind. If that is done, because of, what is the whole idea? If this is meant to be effective, by the time you go in one review, second review, the man under is
I was
actually,
just following the Supreme Court thing, having a two-tier check, that's why.
yeah,
He may,
No, I'll put both ways, Lordship may take a call, Lordship may.
just suggesting everything to what my,
Just see the further steps, if the Lordship approves it. I've come to step 3, my Lord. Lordship may just see step 2. Assessment of the primary board to be ratified by a review board. Review board to comprise doctors outside the treating team of the patient, but at the same hospital where the patient is being treated. So no need to get outside doctors, collector forming a board, etc. In smaller clinics or nursing homes, where there may not be enough doctors to constitute a review board, the assessment of the primary board should be ratified by an independent doctor from a government hospital. Step 4, once the primary board and review board are in agreement that initiating, escalating, or continuing life-sustaining treatment would not be beneficial, give effect to the advanced medical directive and withhold or withdraw life-sustaining treatment accordingly. If the advanced medical directive names a surrogate decision maker, they should be informed and consulted before giving effect to the directive. What would be, where the advanced medical does not exist? Step 1, 2, and 3 are the same. Alternative step 4, if the primary board and review board are in agreement that initiating, escalating, or continuing life-sustaining treatment would not be beneficial, this should be communicated to the patient's next friend. And through a process of shared decision-making, consensus should be reached that life-sustaining treatment is to be withheld or withdrawn. Once consensus is reached, life-sustaining treatment withdrawn. This where advanced rate does not exist, which is the vast majority of cases.
one more thing I wanted to just ask you.
Yes.
You come to paragraph 198.4.5. 198.4.5.
Yes. Even the hospital board, let's say.
That's right. And towards the middle of that,
Yes.
the jurisdictional collector shall then immediately constitute a medical board comprising of the CMO of the district concerned as the chairman and 3 expert doctors from the fields of general medicine, cardiology, neurology, nephrology, psychiatry, or oncology with experience. Now, the experts are limited to these branches. You take a case, for example, a pulmonologist dealing with the lungs. You could have a real problem. There's so many problems with lungs. Why is this expert body confined to only certain branches of the field of medicine? We're just wondering, what is the logic?
Yes, it will be unworkable.
Yeah, how would, supposing you have a pulmonologist, you'll bring, you've got a pulmonologist, DM in pulmonology with huge experience. So is the problem affecting his lungs? How do you,
Especially in Corona, that was the big thing. Your lungs got
exactly, just, struck by it, why, what is this? Should have been in the concerned field, expert in the concerned field.
But what we are saying is just leave it to the goodness, wisdom of the doctors, because we'll have to go some element of trust. If I've got treating
Because
doctors.
we are now in an age of super specialization,
Yes.
and even more than that. So MD, DM, and above that, you go even further. So if you ask doctors, many of them may not really be able to say, I'll have to look it up. Just like lawyers, I mean, it's not anything
Yes.
different. The area of specialization. So that's why I thought in pulmonology, I'm giving as an example. There will be other branches where that expert will really know the latest position or the advance made in the research.
No, I do this a lot. Suppose I've got a kidney problem, I'll typically be in the nephrological
Oh,
department.
that's right.
So if I'm in the brain problem, in neurology. So basically, my doctor will know that Mr. X, the chances
That's
are very
right.
slim.
That's right.
That's how it works out. The only thing is why we put secondary board after discussing the health secretary.
Take a hepatologist.
Hepatologist.
Take a hepatologist, gastroenterologist.
Even colon cancer.
Yeah, not only cancer. There are,
I think it's so complicating it a lot. We simply say a medical board, the doctor teams treating him, plus an independent doctor can certify yes. And by advanced directive is not the, which is the vast majority of cases applicable throughout the country. Today, what happens is the next of kin can tell this thing that instead of we deciding, let the primary board decide. Shift the decision making to a primary board. If the primary board decides, it can't be done. And Manipal Hospital has done a very good example. Lordship will just take page 46 of this spiral bond compilation. What is medical futility? We do not go into today, but there's a lot of literature where there's medical futility.
We can do one thing both.
Yes.
Have a primary and a subsequent board,
Ah,
it's called review board,
review board.
can be comprised to one. And take the independent doctors which are referred to 98.4, just read over to you.
Yes.
Which is or.
Yes.
Not all the doctors should be there. Looking to the nature of the ailment which we are suffering, take that doctor. So it is not all doctors. Doctors of either of the field, looking to the kind of ailment for which he is asking for expert opinion.
What I'm saying is, suppose it's a, say, for example, a kidney problem.
Yes.
Apart from the team,
Same
there will be
approach.
independent nephrologists who will come and.
Correct, correct.
That's a good idea.
This no 98.4.5 takes so.
Yes.
It only comprises of these kind of a broad spectrum of doctors.
It could be any specialization of the person's illness.
Correct. Doctors should be 2 or 3 from these specialties, meaning they were looking to the nature of ailment. Take the doctor from this specialty. This is normally the patients suffer from these very normal ailments, not in general. So what we suggest you, subject to what my brothers also say, make it one board. Primary and review board must become so that it can speed up, simplify, and take
board
a
is
further course of action.
So you're saying one board would be the treating doctors plus an independent.
Independent
That will be
government,
part of
yes,
the-
yes, CMO or whatever.
Or the senior doctor in that field wherever applicable.
And this court has said 20 years experience.
Doctor says,
This court has said 20 years experience of the doctors who want to be a member of the board. It is very 98.4.5.
no, 20 years, that's what that.
20
That also we said was not possible because in many cases in smaller towns, the doctor may not be of 30, 40 years.
You don't find doctors of pulmonologists and oncologists there.
You may not have one. You may
These
not have.
specialties you don't find. You only find in Chennai or in Bombay. You don't find in somewhere in Rajasthan, Sikar. You don't find it there.
But in fact, Lordship comes to Apollo Hospital in
The
Chennai.
simplest.
The board is in English and in Bengali.
Yes.
This two-tier system is introduced with a
And
purpose.
Hindi. Pardon me?
This two-tier,
Simplest and most.
this is with a purpose. Because we know that, no, you cannot simply roll off the manipulation likely to happen. So, and especially when you are taking on the life of a man, that is why it is so precious. Much precious than the properties of a man. That is why this system is staying.
Lordship, we think overnight we'll deliberate upon it. Put a single.
Because it is not that person. Somebody is deciding. Of course, advance, that thing is there.
No,
But
the
still,
reason.
you are taking whether that person's life is to be taken or not. Therefore, it should be.
No, one option is sometimes time is of the essence. Time is important. So time is very, very important. Now, for example, man is gone to a coma. What do we do? Only 10 days have passed. So review board may take time. So either we propose for a review board or we
That
say.
is why we
In
are
the
saying
meantime, the cost
it's not
goes
a
up.
matter which should be
Yes,
done
In the
in a hurry.
meantime, the expense goes up, like
Huge.
expense will go. Supposing you keep delaying it. In the meantime, the man is,
But normally, if a man doesn't have enough means to pay for the life support system, what does the doctor or the hospital do?
No, but they take a form, you discharge like in medical. I know many cases, especially in a.
they'll ask for a
hospitals-
bigger deposit. They'll ask for a bigger deposit.
Yes.
Initial deposit,
No,
plus
I-
deposit,
I know a case.
some
where-
other bill.
where a person
This
has
is the advance directive from the hospital.
where a person has gone to the hospital, they didn't have the advance money to pay, then they shifted in the ambulance to the next hospital, dies on the way.
He dies on the bill.
He dies on the way.
I said he dies on the bill.
Bill, yes. That's why somebody said sometimes for a poor person, like Mr. Natarajan was saying, it's cheaper to die. There's no money for the treatment. That's
Most
hard
of them
reality.
died, most of them died.
Because we don't have social insurance, we don't have.
All these are for those who can afford those.
That is
kind of
exactly what I
life-saving-
was telling you.
Life support system.
Constitutes about a 0.0.
No, but in fact, I would humbly submit that it could be helpful to people who are, say, at the middle class level, who are not completely poor, not completely rich, but they could be ruined because of this.
They would
treatment
not
cost.
go in for the treatment.
Not many of them,
After
people,
a certain stage,
they will say, please,
the
discuss.
relatives will say, I mean, we can't afford it. And if they can't afford it, that's end of it.
Yeah.
Then they have, what's the son? Discharge like in medical.
This we are telling you.
See, suppose, 1 minute before you answer, suppose this person, the sick person is, the family doesn't want him to be discharged. Neither they have enough money to put him on life support. So what does the hospital do in normal practical terms?
The document.
Intensivist repellent for this modification. You know, the whole question is this only. We need some guidance for ethical and humanitarian management. That is why it become inhuman to continue on life support after a certain,
No, we are posing you a question.
yes.
Suppose they can't afford it, what are the doctor?
No, if you can't afford it, sir, that is not a reason to take an end of life decision.
No, what is the pay?
What do we do? No, see, if there is no hope,
No,
then we have to talk.
Suppose there is hope,
If there is hope,
but no money.
then either we give subsidy or move to a hospital where it's less expensive. If there is end of life situation, then we have to take
Suppose
an.
it's not end of life.
No, if it is not severe, we can see the left against medical advice is not human. Because we have to.
So because they don't want to leave,
Yeah, and nor do we want to just send a patient off like that, because
then it becomes a contract kind of
It is
situation,
difficult.
commercial decision.
then we give subsidy. Many times we move the patient to a less
How
expensive.
much subsidy each hospital has?
I'll tell you, sir, there are system. No, I'll tell you.
You have to
I'll give you
basically
example.
go, you just have to go in.
No, sir, I'll give you example.
Ask reality.
I'll give you, there are some hospitals which move the patient to the free ward. Number two, there are some hospitals which give subsidy up to 30–40%. You know, I don't want to take names, but I can give you exact names where all this is done. But then there are hospitals which don't care.
Anyway, we are not so much concerned at this stage with this factor.
No, at the end of the day, there are 2 points, 143.194.
No, so I want to say only one thing in the context of the end of life care that we are talking about. You know, the end of life care we are talking. You know, sir, actually, there are many people who are on life support or about to be on life support, which they don't need, which is futile. And that is well discussed, well defined. We have got an ICMR which has given all these definitions, you know, what is terminal illness and what is end of life and what is futility, all this, what is inappropriate treatment. All these are well defined and submitted with you by the ICMR consensus. Now, this is also available in international publication. In a situation like this, sir, we don't have too much time. You know, every case is not a vegetative state. Vegetative state gives you months and years. But there are situations where it has to be decided within a few days.
Oh, normally,
Now, majority of these decisions, end of life decisions, are taken in the first week, and most are taken in the first 3 weeks. This is all there. The data is there. We have submitted those papers also. Therefore, it is unworkable to have any person coming from outside the hospital, you know, and involved in this decision. And this decision is not easy because we have to respect autonomy also. We have to follow the obligation of beneficence also from our side. So there has to be a cogitation. As the previous common cause judgment has said, there has to be a cogitation between doctors and family, and there should be multiple doctors involved. This is what we'll ensure, sir, in the procedure. Multiple doctors, whether 1 or 2 tiers, but they should be within the hospital. And then if there has to be a review, you may have an independent outside person. But since these are time-sensitive decisions within the hospital, we must have within the hospital, sir. Please ensure this because we have been yearning for this for years now. Because we want to take a humane care of the patient. We don't want to abandon the patient at any stage. If the patient is dying, we don't want to abandon the patient. Send patients along. We want to care for the patient as per the dying patient's care, as per our palliative care. And so we take care of the pain. And
prolonged we, who are you?
we means healthcare workers, which means doctors, nurses, healthcare administrators, healthcare policymakers. All of us are involved in caring of the patient and the sensitive caring of the patient, caring for the symptoms, caring for the dignity, caring for the peace of the patient while dying. We are talking about the death and dignities.
That's
Sir, I am right now officiating Director NOTO, National Organ and Tissue Transplant Organization. And I am also looking after the trauma and injury and violence management program of Government of India. So, sir, I have worked in Safdarjung Hospital, government hospital since last 13 years. The issue being raised, see, first you have asked कि once a patient is in private hospital, he or she has exhausted all the money and all the resources, what is being done? they are being shifted to government hospitals, and in the government hospitals, we get daily up-teen number of such cases. One. Number two, about this advanced directive, sir. Advanced directive is basically a thing which is being asked for the patients who are at the end stage of their life, and it is futile as per the knowledge of that particular time. In the medical science, doctors say that we are wasting our resources on a thing which is going to give us no results. So we want those resources to be utilized for those people who are waiting and who can be saved. So this is the issue for this whole of the agenda. So advanced directive is, as sir has said, the advanced directive is applicable for very, very few people, those who are in the hospital, who are in the terminal stages, and a doctor or treating team feels that they at the present time with the scientific knowledge, it is of no use to prolong the treatment. Rather, it will be better to save the other lives which can be saved. One. Second is this advanced directive.
There's a term for that, I think, during Second World War it emerged. Yes.
So triage is other thing. Triage is basically a thing where
We came across the term during that COVID time.
yeah, triage is something different. That's triage is a term when we have got so many number of people, we prioritize those people whom to take first, whom to take
Anyway,
second.
so this is a bigger.
This is the bigger. So basically, it's to,
bigger track.
it is to help those people who can be saved and don't let the resources based on a person who is already gone as per the present scientific knowledge. One. Now, regarding the boards, sir, two boards need to be there. One. When I'm in a intensive care, I'm basically a cardiac anesthetist. When I am treating a patient, I may have bias. I am giving my 100%. I am engaged with that person. So few element of that personal touch and all these things come into effect. Once the treating team decides that yes, this is the case where our medical treatment is not going to help in any way. So it is always good to take a opinion from the other board. It will remove that bias. So it will be always good that we should be having two boards. Third, this judgment was there, sir, but in the hospitals, what we were facing was process was so cumbersome that it was non-practical. Despite having a judgment, we were not able to implement. There will not be even a single case whether we could have done this in any way. So we need to trust the medical fraternity, sir. It is not a single person who is taking the decision. It is the treating team. And in this team, we are coming up with 3-4 doctors who are part of the treating team. And then once the treating team takes the decision, then it needs to be reviewed by a next team. So it can be done in that way.
Yeah.
And that advanced directive thing, I don't know why we are making it so big a thing. Let us say, even in my 30, I write down an advanced directive. Yes, I have written that. It is of no use. It comes to use only, sir, when patient comes to a hospital. He is on a life-saving strategy, life-saving medicine. Then these boards will be taking decision. This will only help in a case when attendants are saying, because at that moment of time, they are not in a position to take decision. They will say, no, we don't want. And this advanced directive may help us in taking decision at that point of time. That's only, this is it.
Thank you.
Anyway, so tomorrow we'll come with a.
That's right.
So 194.3 and that 194. That last, how to be affected, is multiple boards, etc. We will.
But as the doctor said, having two medical boards serves a purpose.
Yes, yes.
So that, the only thing that can possibly be done, we tell you.
Yes.
We can set certain time limits. Because what is important is, like you said, speed. So once the first board gives a report, we should say that within a particular time, this next board should examine and a decision should be taken.
Yes, that's right.
It is this, once you have otherwise you can go on endlessly.
Yes.
So it will defeat the whole purpose.
Even our view is also that there shall be two-tier system, two-tier check must be there.
Because every day in the hospital is going to cost.
Absolutely. The whole purpose will be defeated, and like he said, it's a drag on the resources.
Sir,
And one, just my colleague, can it be from the same hospital review board?
Yes, yes. Sir, here I will say ki, if in a hospital,
Yes.
all the specialties are there,
Uh-huh.
we can go with in that hospital. There will be many instances when all the hospital will not be having so many number of doctors, then any nearby government institutions can be involved.
See, again, we'll have to come to a definition of which hospital, clinic,
Yes.
small, big. We'll have to have something uniform.
No, what I was suggesting was.
Legislature can come up with a.
Yes, and the part-time, the temporary, let's put up this, let's start implementing it. Let's see how it works out. Once your lordship gives a workable formula,
The only,
we will have a.
the only tweaking that really is going to happen is putting up a time limit.
Sir, that will do.
And sir, one more.
And some doctors are telling me that sometimes outside review may take time. So
That's why you're telling you.
Within, if you can't do
It can be within a time. Sir, second is clarification regarding these specialists, super specialists and general physicians and all those things. Sir, most of the time, these patients are being treated under the care of specialist doctors. So they are under the care of specialist doctor. So in the primary board, most of the time it will be the specialist doctor because intensive cares are being managed by the intensivist and super specialist people. So they will already be under the supervision of these specialist doctors. So in the review board, they should be general people.
You don't find an hepatologist.
They should, the review board should be a general board so that bias is gone. So he is a journalistic person who can ask
Gastroenterologist is
questions.
not there.
Yeah.
Gastroenterologist is not there. We are wondering why.
No, I'm saying let's not give the speciality. We'll simply say the primary
No,
board
It's
is
not there. It is not there.
correct, correct, not there, not there.
Yes.
So it should be, sir, treating team and then it should be reviewed by a general team which is not involved with the care of the patient. Then it will remove the bias.
Can you give us an indication? You were in software zone.
Yes, sir. I am since last.
How many beds are there?
Sir, 2950 beds are right now there, sir.
How many deaths take place each day?
Approximately, sir, around 15 to 20 deaths per day, sir.
Okay.
2,950 beds.
And then, sir, 15,000 per day attendance of OPD. Then we have got around 2,500 daily attendance in emergency.
We were looking at the number of cases where this
2,000
review board may have to devote time to.
Yes.
See, you're talking about Delhi, which is fortunately blessed with a number of premier government health institutions like AIMS,
Sir,
Ram Manohar, Saptarjang.
sir,
You're talking about this being across the whole of India.
sir.
My brother said, you go to Rajasthan, you go to Madhya Pradesh, you go to any Uttarakhand. I know from Uttarakhand, I went to Aldwani Medical College. I was shocked to know that they didn't have a, what do you call this, surgery who does kidney surgery. That is,
Urologist, sir.
you
Urologist.
you don't have a urologist.
Yeah, yeah.
So
Nephrologist is different, sir. Urologist.
despite the best efforts of the government, they were not able to get a urologist because of the difficult conditions there.
Yes, sir.
So every part of the country is not the same.
Yes.
Correct? There's a variation, a lot of variations are there. When you apply it, you'll have to apply all over the country.
Tell us one thing.
Tomorrow.
Doctor, medical review board. If it's not possible, don't go for medical.
Within the time limit.
Yes, time is an essence. Time is an essence. So as far as possible, review board is possible. If not possible, that board can take a decision. If
Sir.
not possible,
Can.
so that
Sir, the issue is that it should be practical.
practical.
I agree with you, sir, but you have said that after specialist, why journalistic? Here, sir, I will tell you. See, in our medicine, when we do MBBS, when we do graduation, we are taught each and every subject there. So after that time, we choose a field. That this super specialty thing is, I don't agree with it. It is actually subspecialty. It is actually subspecialty. They have come up with this subspecialization, but a journalistic person will be looking after all the, as a journalistic way, he can ask the questions.
You don't put your personal perception here.
He's saying a general physician.
General physician will be the person who knows each and everything.
People go on fighting to get this seat for super specialty.
Yeah, sir, that is because I am interested in that. I want to pursue a particular, see, as in your law, you have different specialization, that there is a criminal law that.
Let us not go into all these issues now. Tomorrow we'll come out with the proper solution, what can be done once for, we will not debate upon it.
Just for 2 minutes, put the matter in perspective. So in this very case, your lordship has held that a person in his sound mind and conscious state has an indefeasible right. Several paragraphs deal with it. Final conclusion also says to refuse treatment of any kind. So even to your lordship's question, suppose I say that look, some doctors are telling me that there are very good treatments for my cancer. I don't want to take chemotherapy. I have an absolute right to refuse it, and nobody can force me to take it. This is one clear proposition laid down in so many words in several places in this judgment.
No, it doesn't say that. It says,
Absolutely.
no, it says that it has to be found that he has reached the terminal stage.
No.
Yes.
Not at all. Not at all.
Yes.
That's only about the advance directive.
That's what
Now, your lordship
we are about the advance directive.
No, I'm not on that. I'm saying that in general, one has an absolute indefeasible right in a sound state of mind
Correct.
to take a decision not to take any medical treatment.
That's right.
That's an indefeasible right.
Nobody can
Yes, correct. We are now dealing with only a very peculiar situation.
Very narrow area.
And the narrow area is where I am not in that state of mind to take a decision. And my wishes are required to either override the wishes of my primary caregivers
Correct.
or override
Medical.
obligation of hospitals. Hospitals are faced with this problem that even when a person is in a terminal state, they are unable to withdraw life support, etc. He says that they are sent to a government hospital. So they are unable to do what they should be doing in order to devote their resources to more productive people. So it is only those.
There is one more thing to it. Not all hospitals who are actually paragons of virtue, because there are many hospitals who put them on the ventilator. Perhaps they are dead. Even after a long time, they come with huge bills.
Yes, absolutely.
It happens.
Absolutely.
Not all
there, of course, the primary caregivers
Yes.
can take a decision. But the problem is primary caregivers feel sort of morally in a dilemma.
Correct.
Well, how can I withdraw life support? This doctor is saying, even if that person has expressed a clear wish, saying that, look, I don't want to be put on a ventilator. Suppose I just say, I don't want to be put on a ventilator. I am giving this in writing right now that should a situation arise, whether or not the doctors say that I can be saved, I don't want to be put on a ventilator. I respectfully submit, my Lord, that declaration has to be honored. Nobody can override, not even his relatives, nor the physicians can override the declaration if it is clear that he has said it.
Could you explain 198.6.2? Please read that. We are all saying this. Kindly tell us what is the meaning of this 198.6.2.
So,
Please read that.
198.6.2 advance directive shall not be applicable to the treatment in question if there are reasonable grounds for believing that circumstances exist which the person making the directive did not anticipate at the time of the advance directive and which would have affected his decision. That's all right. But
what is the meaning of that?
The meaning is that whatever may be the meaning of that, I am saying if a person,
we have to understand it.
if a person says, look, I am aware, suppose he says, I am aware that there might be future treatments which might save me, but I, on principle, do not want to be put on a ventilator. I do not want to take any chemotherapy drug. Suppose he says that, very clearly says that, look, whatever treatments may come in the future, anticipated or unanticipated, I do not want to be put on chemotherapy. I do not want to be put on a ventilator. And my wishes should be honored. If it is clear that this is his expressed wish, and then, my lord, what this does is, it just overrides the decision of his next of kin, who may want to put him on a ventilator, or the hospitals who for commercial reasons may want to keep him on a ventilator. So therefore, it overrides all that.
Provided it is terminal. Again, we are telling you, unless it is terminal, this court has not said it will be.
Your lordship is right. Your lordship is right.
We had discussions with the ministry and other people, they said, that's why the primary board can override the advance. They may say, no, we can be treated.
Absolutely.
Sir, here I will like to submit what sir is saying is, there is a sect in world which is known as Jehovah. They have religious obligations that they will not accept any outside material in their body, and we respect it. But this is beyond this, I think. Right now, we should think about the people who are terminally ill and are being, doctors are being forced to continue the treatment where it is futile. So that is a subject in itself.
One thing is mine.
Yes,
If your statement is taken at the face value,
yes.
what about the medical negligence?
Medical
Medical negligence. Negligence.
negligence.
Day in and day out, doctors are being tried for medical negligence
That is why.
and he's asking that because his will has to prevail upon.
Yes,
And
yes.
doctor is not to treat him.
So they will be
Over the
relieved. They will be
You will double
relieved.
tomorrow.
They will be relieved of this charge of medical negligence because they are just obeying.
So many
his
matters coming to
directive,
us.
which is ordered to be obeyed.
If he can be treated, then his will as per 98.6 has to be taken.
Lord, that's the problem.
No,
This is the
sir, as long as patient is
That's
conscious.
Datta. This bench is concerned, equal strength, 5 judges. There is a 5 judges bench. This application is more to see that if it can be tweaked a little bit. Modified. We can't go beyond that.
Yes.
We must, basically, we can't, otherwise this will be a re-hearing, not a review.
We go to 7 judges.
All that we can do is to make it practically possible, but at the same time adhering to the safeguards.
We can fill up the vacuum, that's all, nothing beyond
That is
that.
all, nothing
The
else.
problem is, my lord, that the safeguards have become so onerous
Correct.
in terms of judicial magistrate, first review board, second review board, etc., that they have become totally impractical, with the result that there is not a single case in this country in these 5 years
Which has really happened.
There it says it has to be stated without a trace of doubt that the right to live with dignity also includes smoothing of the process of dying in a case of terminally ill patient or a person in previous with no hope of further recovery. All those things are that is under to note the conclusions. That also is.
That's mandatory.
We are saying these are all, what
For afternoon, the lordship will.
Afternoon, we will be taking item number 2.
Yes, no, I think this, we can have it tomorrow, 2 o'clock.
Tomorrow, it should be over by tomorrow.
At 2 o'clock, no? Because this spills over.
2. So that by the time,
We give also time to.
because they are, yeah.
Hi, I'm obliged for accommodating.
One thing before he starts, just for Lordship's knowledge in the facet. Let us say intervention was filed a day before the CB sat. Your Lordship made it clear on Thursday that your Lordship would not want to go into this. In any event, Manas, it is unprecedented that when the bench is ending, your Lordship has intervened. I would say with respect, it also reflects politicization of the civil service. No point him putting up 2 associations, I start putting up 2 associations. It will send your Lordship's entire time schedule, of which some discipline must be maintained, into a complete curve. I'm leaving these 5 thoughts with your Lordships. Your Lordship is towards the end, Manas. I will, if my learned friend sticks to his 15 minutes, that is, I will barely finish at 4 o'clock. Just kindly, Manas, do not allow this.
Thinking was,
Mr. Solicitor, what we can do is this, so that Premchand Jain is not left undealt with, not dealt with by you. After you finish, when you're towards the end, you can take 5 minutes and distinguish Premchand or, whatever you want to say.
Yes.
And thereafter, all that we'll do is that Mr. Salve, only on Premchand Jain, can give us a note, or you can treat it as your note and give it to us in writing. That's all.
He is the sizer of the proceeding. He doesn't have to rely on Mr. Salve. He is the master of the. So he can deal with it, and
Nobody is master. Nobody is
You can also give us the note, no problem.
rely on
I'm
association.
not addressing, I'm not arguing on behalf.
What you can do is that you can give us the note, even tomorrow or day after with a copy.
Yes,
of
we
Dr.
can both give one page note on each.
Yeah, 1 page note. You can give your 1 page note to Dr. Singh by tomorrow. You can
Much more
circulate a 1
I
page.
leave it at that. I leave it at that. Only.
But we'll require an answer from you on Premchand Jain, how you are approaching it,
Incidentally, he doesn't find a mention in his written.
That, my lord, honestly speaking, we as lawyers had a detailed discussion. I don't know why should we be afraid of, my lord, Salve addressing on 10 for 10.
No, that's not the point so much.
said
It's
argue
about
for
the
him.
modalities of
Salve
our institution, man.
Not be given 10
Frankly,
minutes.
Mr.
There is a discipline of
Mehta,
the court with respect.
normally, as you know, in my court, I mean, any intervener comes, we'll just already, we'll hear you for 2 minutes. It's easier that way.
I'm sorry.
Constitution bench, constitution bench to allow some
Never done.
IAS Officers Association, there's some point in what Dr. Singh says, don't politicize it between associations. Therefore, you can say the same thing. We'll give, you can put a note on the record.
I understand Dr. Singhvi's concern.
Yeah.
I understand Dr. Singhvi's concern, but I can't argue, my lord, beyond that.
Now, suppose after Mr. Salami, Dr. Singhvi says, well, tomorrow there's some intervener. What do we do? We'll have what sauce for the good, sauce for the gander.
Anyway, Lord, it's not for me to, my lord,
Isn't it?
defend.
No, I don't want to push on it. Lordships don't want to hear. It's perfectly right.
And you can give us a small note.
Yes,
and that's-
obliged.
Yes.
So, my lord, I would, your lordship wants me to give a note, or even that your lordship would not want to encourage.
There's no difficulty. You can give us a small note.
Within
Just give it
X
to.
days, 1 day or 2 days.
So long as he doesn't argue, my lord, Dr. Singhvi may not have any objection.
Sorry.
So long as Mr. Salve doesn't argue, you won't mind.
So long
That's
as
right,
you
my
do
lord.
not
That
Mr.
is-
Salve
and we all know, my lord, this has nothing to do with
do not
association.
blatantly back from Mr. Salve while saying that you are not batting for him and don't set up an association of which you
No,
concede
this
that
is
you
not
are
setting
power.
up.
I am not
What if
getting
I was
anyway,
to say
my
I
lord,
am
it's a
assisting
All
a
right, all
solicitor
right,
and
all
I want to take
All
15
right,
minutes?
all right. We'll now, Mr. Solicitor,
Let's not go that way.
Yes. So the third layer.
My lord, we were on, and I'm skipping, my lord, something which may not detain your lordship's attraction, my lord, much. Lord, I was on page 38, and I'm
Yeah.
wrapping up, my lord. Is Das. I'm not reading Das, my lord. Das is, my lord, subordinate services, where the appointing authority is the chief secretary. My lord, that's all. I have quoted the relevant rules. The rules are framed, my lord, by the central government, and, my lord, these are central rules, and the chief secretary is the appointing authority. I don't think, my lord, anybody would be fighting for control over Das. Lord, in fact, this word control over bureaucracy itself is a very derogatory.
And DAS postings are done by whom?
Chief Secretary.
By the Chief Secretary.
By the Chief Secretary. Under the rules, my lord, kindly have a look at, my lord, the rules, my lord.
And the rules,
Page 59.
CCS rules.
And the
rules.
Yes, CCS rules, yes.
And also the.
No, even DANIC rules, even DAS.
Then it won't apply.
So DAS has rules. Lord, please have a look at para 106.
Oh, then
106. Rules, that is Delhi Administrative Subordinate Service Rules, are made in exercise of the powers under the proviso to Article 309. Then your lordship would come to, my lord, kindly come to 2B. Appointing authority in relation to grade 1 means the chief secretary, and in relation to grade 2, 3 and 4 means the heads of department concerned for the purpose of these rules, as well as central services, classification, control and appeal. That's all. But they are central services, my lord, that's all I am saying.
Right.
Now, your lordship, my lord, the Chief Justice of India, my lord, pose a question. That what happens, my lord, when there are appointments to be made? My lord, the Dr. Singhvi said that we wanted to make some appointments, and there was no resistance, my lord. Fortunately, he also didn't say, but we can't even make appointments. But we can't help it. That's the statutory regime, the appointment, recruitment, etc. is done by UPSC, and my lord, as per the statutory rule governing, please come to, my lord, page 42, the last point, my lord, in this written submission.
Posting and transfers.
Posting. The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated so and so. Not
Where are you reading?
I'm sorry. 118, para 40, page 42.
118.
118.
Page 42, para 118.
Yes, posting regulation.
Yes.
The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated 13th July 59, not under challenge. All civil posts in the government of National Capital Territory of Delhi are governed by the Central Civil Services rules as per the aforesaid notification. All such posts are services under the Union as per entry 70, list 1. All gazetted posts same are filled by exams conducted by UPSC from time to time, whereas all non-gazetted posts filled by Delhi Subordinate Service Selection Board. LG doesn't make their point. As per transaction, this is relevant. As per transaction of business rules of NCT of Delhi, any minister may recommend the creation of new civil post in pursuance of a policy decision which is placed before the Department of Finance, GNCTD, because it needs financial approval, but finance of the Delhi government elected wing, in accordance with the rules, and thereafter before the Council of Ministers of GNCTD, the decision taken by the Council of Ministers is forwarded to the Honorable Lieutenant Governor for his approval. Upon approval by the Lieutenant Governor, which is always granted if the proposal is not in conflict with any legal provision. So that is under 239AA4. The proposal is given effect to and the recruitment process is carried on as per the process prescribed in the cabinet note, or else the same is forwarded to the Delhi Subordinate Service Selection Board conducting the recruitment exam in accordance with the rules framed by the framework. That's all, my lord. Minister originates the proposal, it goes to Finance Department of Delhi, Finance Department approves, it goes to Cabinet, and, my lord, the LG forwards it for the appointment unless it is, my lord, contrary to some law. That's how, my lord, this is created. My lord, now the position is this. Before, my lord, I answer the question of Jammu and Kashmir. Now the position is this. My lord, your lordships are requested to examine whether Delhi has the power under entry 41 rule, under entry 41 list 2, without they showing how they fall within. I have shown, my lord, 3 things. Insofar as it is applicable to Delhi, that is to union territories, and therefore your lordships will examine whether any union territory can do this. That will be the test. Union territories, my lord, kindly recall.
Yes, yes.
I have also pointed out to your lordship statutory rules or rules framed by the President under Article 309 proviso, which are not under challenge, conferring something completely different than what they are praying for. They are not under challenge. I am pointing out statutory notifications of the President, which are not under challenge, except 2015 notification. Lord, which, I'm sorry, Mantra.
Yes.
Which is a notification traceable to Article 239, read with Section 41 of GNCTDA. So, if your lordships were to hold that the entry falls with union territories, not necessarily, it would temper with 239AA3A, which says union territories, then even Lakshadweep can have their own service. To your lordships, ultimately be setting aside the statutory rules without there being any challenge.
Yes.
And most importantly, my lords, a very harmonious structure which is in existence since beginning of the union territories will be disturbed because of some hypothetical problems being, my lord, highlighted.
Right.
Now, my lord, coming to the Jammu and Kashmir, my lord, and that's, my lord, the last submission. My lord, please take, my lord, the act. My lord, Jammu and Kashmir, my lord, it's volume 1. My lord, it's volume 1, page 1478. PDF page 1478. I'm sorry, P1482.
Volume 1 means convenience compilation.
Hmm?
Convenience compilation.
Convenience compilation.
1478.
But I would make my submission of Article 4 read with Article 246 good. I have examined that, my lord, in detail. Why, my lord, Jammu Kashmir
1478.
1482.
1511, my lord, PDF page 1511
No, no, PDF
is my lord, the relevant provision, which
1511 is the relevant portion.
section 93 of state reorganization. Act. My lord, please bear in mind, this is the state reorganization. Act.
Which section you want us to see?
Hmm?
90. Which section?
93, my lord, 93, which my lords would find page 1511, PDF page 1511. Your lordship.
1500 is the second schedule.
Pardon me?
1500 is the second schedule.
No, my lord, PDF page 1511, my lord, otherwise 1507. If your lordships are looking at the right side pagination, 1507, section 93.
Yes.
The Public Service Commission for existing state of Jammu and Kashmir shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. There was no, this is a sui generis case, where there was already an existence of Public Service Commission. It became UT. It is continued under section 4, read with 246.
Yes.
So kindly, my lord, have a look at section 4 once again. I'm sorry, article 4 once again. For Lord, I think I'll be able to make this submission. First is, my lord, 3. Kindly see article 3. Formation of new states, and your lordships would recall, Lord, state here may include union territory. Please see. Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, form a new state by separation of territory from any state, or by uniting two or more states or parts of the states, or by uniting.
So according to it's a supplemental, incidental and consequential provision under section
Provisions which would not be treated to be an amendment of the Constitution. My lord, a Constitution bench had an occasion.
Okay. We got your point. You got your point.
I'm sorry, my lord, one more thing. This very provision came up for consideration before a Constitution bench of your lordship. Can I read, my lord, only 2 paragraphs?
Which is that?
Lord, that, my lord, we have given, my lord. The book, my lord, we have given the citation. Lord, here, when Punjab and Himachal were separated, the number of legislative assemblies were changed, which clearly amounted to amending the Constitution. So there was a clear breach of Articles 170. Clear breach. Lord, that is Mangal Singh and another versus Union of India, 1967 SCR. 1967 2 SCR 109. Lord, kindly come to 5, para 5. I'll read, my lord, the relevant part of it. Para 5. Lord, there were changes in the legislative assembly numbers in violation of 170, Article 170. Constitution of Legislative Assembly of Haryana. Lord, let me read 4. Section 24 of the Act. It is provided that the total. I'm sorry.
1 second. Which AR you reading? You got an AR actually.
Here got AIR.
AIR, my lord, your lordships have.
Mangal Singh.
Yes. Mangal Singh versus Union of India.
But paragraph will be
No.
different.
That's a different Mangal Singh. This is a different Mangal Singh.
Starting is by section 24.
1 second. Name.
Oh, it's not even a constitution.
So this is some CPC. Order 22.
Lord, this is by my Lord Justice J.C. Shah.
No. Bhargav.
That is page 944, brothers. Page 944.
Lord, 944. I'm sorry, we gave 944 only.
We are
AIR.
having AIR.
There's a Mangal Singh versus Ratnu Devi.
AIR 1960. It may be our.
944.
AIR 1967 SC.
The first volume.
First volume.
First volume. First volume.
Appears to be matched. our mistake.
And because that was 3 judges, I was wondering how, it's not a CB.
No, Manoj, this is a CB. This may be a larger bench because in those days, Manoj, maybe there was not necessarily a reference, but maybe a reference also, Manoj. It's not coming out. By Chief Justice Subbarao, Justice J.C. Shah, Justice S.M. Sikri, Justice Ramaswamy, V. Ramaswamy, and Justice C.A. Vaidyanathan.
मिला आपको भी दे दो
Read counsel. We'll hear.
No, I would like the Lordships to read, because this would, my Lord, touch upon that when it is a state reorganization, all incidental provisions, even if that amounts to amending the constitution, is permissible. It's my Lord, highest plenary power of the parliament. My Lord, kindly come to the my Lord, para, whichever is your Lordship's para, which starts with
para 6 actually.
By section 24, your Lordship, sir.
No, actually in para 6, the law so made may also, second column, may also make supplemental, incidental and consequential provisions, which would include provisions relating to the setting up of legislative, executive and judicial organs of the state, essentially
Yeah, I can hear you, but my video I'm not able to see. Hello? It's switched on, but I don't know why. Ellen, we could not connect to selected camera. On just a minute. You can hear me, right? My audio is fine. Huh. Video is not on. Yeah, I'm trying actually. I don't know why it's not getting on. Just a minute. It is showing on sign only. Sure, please. Okay. Okay. Okay, fine. Cut ಮಾಡಿ call. Yeah, I'm audible.
Rules were amended on December 2167 by providing for a joint cadre in relation to UTs and Northeast Frontier Agency, and the central government formulated the aforesaid recipe to extend the Delhi Himachal Pradesh cadre to all union territories by absorbing the officers of that cadre and by appointing to it officers of the Indian Frontier Administrative Services and all other union territories at its initial constitution. The joint charter for all the union territories was brought into existence from January 1, 68 by GSR so-and-so, published so-and-so, and thereafter it says the petitioners in the High Court challenged the creation of new joint cadre for all the union territories and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of Article 312 of the Constitution and All India Services Act 51, as it was not common to the union and the state, inasmuch as a union territory was not a state, and the recruitment of the respondents concerned to the joint cadre was contrary to the provisions of Section 3 of the All India Services Act 51. If your Lordship sees this Section 3, it would be, my Lords, at page number 824, volume 1. Section 3. PDF page is 824, my Lords.
Sorry, at page?
PDF page should be 824, your Lordships. This is the All India Services Act 1951.
Same
Just
volume.
serial number, same volume. Is it serial number 8? 9. Serial number 9. Sir.
Yes.
It says, my lords, the central government may, after consultation with the governments of the state concerned, including the state of Jammu Kashmir, and by notification in the official gazette, make rules for the regulation of recruitment and conditions of service of persons appointed to an all India service. So what your lordship sees here is that there is a mechanism of consultation which is contemplated here. So the argument was that if union territories which are not state, and if they are taken to be equivalent to the state, then how will they consult themselves? Was the sort of conundrum which was contemplated, which lordships will emerge little later. It says further in para 3. The High Court examined the question whether the union territories were states and reached the conclusion that this was not so. It therefore held that Rule 4.5 of the recruitment rules was ultra vires the Constitution and the All India Services Act, for the cadre in question could not be said to be in common to the union and the states. The High Court also observed.
Yes.
That the central government was itself the state government for purposes of a union territory. The central government could not consult itself within the meaning of Section 3. So this was the problem, my lords, that they posed for themselves. The Honorable High Court had posed for itself. And then, my lords, they, on the interpretation that a union territories cadre, because at that point in time, the union territories, the placements in union territories was being done from Himachal and Delhi cadre. So after Himachal became an independent state, then there was a need for making a UT cadre. So what was initially done was that all union territories were clubbed together and a solitary union territory cadre was carved out. And later on, it was in any case in 1972, this problem was resolved when the joint cadre and the cadre control rules, etc. were formulated. Eventually, after when Meghalaya was carved out from Assam. So for a brief period, there was a gray area. So during this period, this question arose. And their lordships, in fact, relied on same, my lords, 358 of the General Clauses Act, which is, my lords, backed by Article 372 and 372A. And 372A was brought along with the 7th Amendment when a State Reorganization Act was brought and union territories were created. So this was very simply answered by the lordships in Prem Kumar, that for the purposes of all India services, we can include union territories and we can read them as a state for the purposes of cadre allocation. So that was the limited point. And this is what your lordships have also dealt with in paragraph 458 and 459 of Constitution Bench judgment of 2018, your lordships. If I'm allowed to read 458.
Para 8 actually.
488. 881 of the first.
Four double
488. If your lordship sees, in Union of India versus Prem Kumar Jain, a bench of, sorry.
Yes.
Our Lordship Justice Kohli has have it. This is 4881.
Give me a moment, isn't this 4881? Right. Yes.
It's para 458, Lordships. In Union of India versus Prem Kumar Jain, a bench of 4 judges of this court dealt with an appeal from a decision in Prem Kumar, which is Union of India of Delhi High Court, which had quashed a notification of the union government and a scheme for the formation of a joint cadre of the Indian Administrative Service. The High Court had held that formation of a Delhi Himachal cadre of service to be ultra vires. The creation of a joint cadre for all union territories on 1168 under Rule 3.1 of IAS Cadre Rules 54 was challenged as being contrary to Article 312 and All India Services Act 51, as it was not common to the union and a state, a union territory not being a state. the High Court held that union territories not being states, the action was ultra vires. In appeal, this court observed that it was not necessary for Parliament to make a law providing for the creation of a service common to the union and states under Article 3121 in view of clause 2, which provided as follows. And then 312 is quoted by your lordships. It says, the services known at the commencement of the Constitution as the Indian Administrative Service and Indian Police Service shall be deemed to be services created by Parliament under this article. So that was a deeming fiction, and then your lordships have held. Section 3.1 of All India Services Act had a provision for making rules for the regulation of recruitment and conditions of service of persons appointed to an All India service after consultation with the government of the states concerned. The issue was whether duties could be states for the purpose of such consultation. This court held that the expression state having been defined in section 358 from the commencement of the 7th Amendment to the Constitution in 56 and the President having substituted a new clause 58 in section 3, there was nothing repugnant to the subject or context to make the definition inapplicable. The High Court was held to have been in error in holding the UTs were not states for that purpose. Now in 459, it has been observed whether the expression state in the Constitution would cover a union territory is a matter to be deducted from the context. So this exactly, my lords, is our submission with regard to the entire conspectus of controversy, that whether this entry 41 in list 2 has to be constituted as being available to GNCTD or not is to be seen in the context. And merely because in a particular definition it is stated that a union territory in a given context may be constituted as a state, it doesn't mean that it is there, it is so in all respects. And this exactly what your lordships have clarified in 463, paragraph 463. If I come at the bottom of, let me just conclude, my lords, then I will come to paragraph 463. I am reading from fourth line. Hence, the inclusive definition of the expression state in section 358 of the General Clauses Act cannot apply to the first schedule. Similarly, in Article 246(4), which enables Parliament to make laws with respect to any matter for any part of the territory of India not included in a state, the definition of 358 would have no application, having due regard to this context. So this is, my lords, a very clear finding. Your lordships have clarified this aspect, that while exercising any power under 246(4), what are the parameters available? And this was explained in the decision of Kanya. When there is something repugnant to the subject or context, the definition of 358 would have no application. And this, read in conjunction with 463, if your lordship just scrolls down and sees paragraph 463, and just above placetum G, 3 lines. Hence, the expression, insofar as such matter is applicable to the union territories, is
Yes.
In fact, my lords,
You've got, now you've got understood from that,
Lord, just to
two
conclude
paragraphs
the
make
point,
it very
Lords.
clear.
Just to conclude the submission, your lordships, to say that Prem Kumar Jain has the effect of making Part 14 available to the Union Territory is a completely misconceived proposition, because the context of Union Territory can be gathered from other parts of the Constitution. We don't have to go to that definition of 358 in this, because it is available from 239 AA itself, because it is clarified, because when 239 AA is structured and dedicated only for the governance model of Delhi, then one need not travel anywhere beyond.
That is considered. That is considered by the Chief Justice saying para 358. 458 to 463.
Yes, yes,
It has already been taken.
Yes, this has been taken.
Indian judgment is also considered 9 bench taking a contrary view. The state does not, Union Territory does not mean the state, etc. That has been dealt with and considered.
About this is exactly the proposition. So I am here, my lords, only to clarify this aspect, that so far as Part 14 is concerned, it does not, my lords, even by implication, suggest that this is available to a service or this can lead to a creation of a service other than what is contemplated in Part 14 is, and it has to be seen from the lens of Article 308 and 309, which make it abundantly clear that what kind of services are contemplated in Part 14. That's
okay. Thank you, Mr.
Very grateful.
Thank you, Mr. Yes, Dr.
Please, Your Honor. There is just a word about the logistics. We have been taking notes from the last Thursday when he had argued sometime and made a rejoinder note. Then we tried to keep on updating it on the computer here till about 11:30. Then we ran out of minutes, so we've got a rejoinder note sent to your lordships. So
yes, we got your rejoinder.
I'll do that first.
It's there.
Then I will do equal number of points on the balance part of his arguments till lunch. So I'll do about 20 broad heads points, and I'll be very, very pointed and quick. I appreciate the time. I know we are racing against time. Your lordship, sometimes exceptional circumstance gives me a little over 4 if necessary. I will not repeat. I'll be very fast. Now, my first preliminary point, and that preliminary point is important. Forgetting all the details we'll come to, is that I beseech your lordships, especially in rejoinder, this is important, that this is a case about all the points we have both argued and are going to argue. But it is equally, a case about black and white, about clarity, about minimizing areas of gray. If I may say so with the deepest and genuine respect and humility, look at the tragedy in this case. It starts in the High Court Division Bench. It goes to the Honorable Supreme Court. The Supreme Court, that is number 2. Number 3 refers it. The third stop is the Constitution Bench. The fourth stop is a further division bench of the Supreme Court. 3-judge bench. Now, why should your lordship at all be having a Constitution Bench? Because according to me, and I may be wrong, but I do believe that your lordship's tried, as your lordship does, perhaps to reconcile and harmonize. And there, the black and white got sometimes blurred into grey. That is certainly not what I would want, but I believe that is also not what your lordships would want for the future. That this litigation recurs because of, as they say, you can't please everyone. You can't even half please everyone. And this is something which is going to recur unless there is a certain clarity. It has to rest broadly on black and white. Related to this point, I am not seeking any largesse from anyone. I am seeking my right, my constitutional right, as an elected representative government. I am not seeking my learned friend's sufferance or largesse that he'll give me something or not give me. I am seeking the realization and the actualization of the only animating purpose of 239 AA. Because 239 AA is in the constitutional book, nobody can negate it by saying, I don't recognize 239 AA. I dilute it by a parliamentary enactment. Nobody can do it, your lordship knows that.
But
equally, there are ways of
what is it
circumventing it and reducing it.
what is it that the GNCTT really seeks? I mean, is the now what you really seek clarity on is that you must have the power to post officers, or what is it that?
No, Manoj, that's the example we are putting in. We seek clarity on this, Manoj. NCT, I'm going to harmonize. I'm not against harmonization. I'm going to harmonize.
At the end of it, if we are with you, what is it that you would?
Yes.
The clarification.
NCT, I mean, this is oversimplifying. This is the beginning of my rejoinder. I'll oversimplify at the risk of oversimplifying, but I'll be elaborating. So, Lordship will bear with me. Jammu and Kashmir will come into it. The civil service rules will come. I've dealt with everything. But just to answer my Lord's question directly, and as well as forthrightly as possible, I am seeking what is rightfully mine in legislative terms in entry 41. That's the first answer to my Honorable Chief Justice's question.
Just a second.
My legislative rights in 41. As indeed all my legislative rights, that's the second answer to my Lord Chief Justice. As indeed all my legislative rights under every entry of list 2 minus 3 entries. I'm being blunt, because this is not the way to put it. I must elaborate first, but I'm doing it the reverse order. So Lordship will allow me to elaborate after this. Thirdly, I am seeking all those executive rights and powers which go with this A and B. That's my Siemens. The effect of this is D. The inexorable effect of this is D. Namely, that even as per their own rules and as a necessary consequence of A, B, and C, I must have the right to choose whom to post where and whom to transfer where. But that, fellows, will fit into the legal harmonization above of ABC. It's the inexorable and inevitable consequence of ABC. So this is, fellows, the more... But let me just continue with my theme. The first theme was, fellows, perhaps your Lordship would not want this situation to recur for lack of clarity. And as I'm reminded, in my student days, fellows, Margaret Thatcher had this famous phrase that if you stand in the middle of the road, you have danger of being struck down by traffic from both the right and the left. That is not against, fellows, reconciling and harmonizing, but sometimes, fellows, as these cases illustrate, your Lordship, with the best of intentions, bona fide, may not solve the problem which has, fellows, been harassing this court for 3 or 4 hours.
Two swords in the same sheath.
Two swords in the same sheath is Dr. Ambedkar's formulation, incidentally, was for the governor, and your Lordship remembers, just to digress for 30 seconds.
Cuts both
in the Constituent Assembly, absolutely correct.
It cuts both ways.
Scabbard was used, or sheath, I don't remember. Very interesting. In the Constituent Assembly, there was a direct proposal, debated for more than a day, that the governor should be like a chief minister. He should be a nominee who is actually exercising executive powers, or at least far more than today's governors do. Then that phrase was used, which Justice Narasimha has just opined. So, and who's going to do it? Who's going to demarcate? Only your Lordships. Therefore, and that poet Frost put it even more interestingly. He said the middle of the road is where the white line is, and that's the worst place to drive. Since your Lordship is talking so much about gears and clutches and cars and steering wheels, it's the worst place to drive where the white line is going. And which line goes which side? Only your Lordships. All this rest of us is sermonizing that we will sit together and sort it out. It will never happen. It can't happen. Your Lordship lives in a real world. And it is because we have to smell the coffee, it's only your Lordships who will lay down those lines. Point number 2, I have already dealt with in paras 12 to 19. So I'm saving time by repeating what I've done in my original submission. The facilitative function and not the limiting function of insofar as. There are 7, the heart of my submission is those 7 paras actually, 12 to 19 inclusive. And within that heart, para 16 demonstrates why, for the reasons I have itemized, it is facilitative and not restrictive, limiting, or reducing to vanishing point. So may I not repeat that, but I would request my lords to kindly underline and note those paras, and especially 16, and take it as reread to your lordships. Take it as having been read by me. I've given those reasons facilitated. Otherwise, your lordship would have to amend, your lordship would have all kinds of problems. And it is intended to suggest that mutatis mutandis, what it should do. It is not restrictive. That was the argument in a general sense. Then, the third set of submissions is to remind your lordship, this will be very brief and pointed because your lordship has seen it, that this aspect of insofar as being exclusionary was specifically noted in para 39 of Chief Justice Mishra, which my lord has noted at page 4773. Para 13, specifically. And I read that to your lordships in the opening with immediately after 39, para 222, 223 and 224, where the scheme of distribution of legislative and executive powers is discussed by the same judgment. Read together, it is clear that insofar as has been decided by your lordships in the Constitution bench, not to mean what the government of India is today canvassing. So read 39 with 222, 223 and 224. This 223, 224 is 4773. I'm sorry, Malas. 39 is at 4714. I gave the wrong page to lordship. Para 39 is at 4714. Para 222, 223 and 224 is at 4773. Then, Malas, the judgment further in 224, it's a very important para to repeat, Malas. After noting, that is 224, para number, page 4773, says clearly that all entries are available minus, it says that except 1, 2 and 18. And bullets.
Which is that para?
That is 224, 4773. And your lordship may now turn to my written joinder note. It's quoted there.
Para 2. Para 2.
That
para 2 of your.
I'm grateful. No, para 3. My lord is right. Para 3.
3 also.
We'll just see the last small Roman 3. That will be quicker. You also don't have to go to 224. Such an interpretation would thwart so need not go to 224, just see it from here. May I read, Malas? Such an interpretation, and that such an interpretation in the preceding part is exactly what is argued today, would thwart any attempt on the part of the Union government to seize all control and allow the concepts, mark this word, pragmatic federalism and federal balance to prevail by giving NCT of Delhi some degree, there is some misprint there, of required is wrong. Yes, I'm sorry.
Required independence.
Now, your lordship may note here, because it's better to note here itself to save time. This word pragmatic federalism is dealt with by Chief Justice Mishra in paras 125, 127 and 128. Para 125, 127, 128, especially the last two. So, Malas, before I come to Chief Justice Chandrachud's judgment, Malas, if this is left open textured, then Malas, we are opening the door to an open crisis every day. This can't be left open textured. Then, Mr. Chief Justice Chandrachud in my next para 4, and which is your lordship's para 362, page 4883, says cabinet government in in 239AA necessitates that the court pursue a line of interpretation which does not detract from the fundamental principles of representative government. This is just a recap. Manoj. I've dealt with Westminster model. I've dealt with civil service. What is the meaning of Manoj, cabinet government and representative? Government. If Manoj, by a circular route, you are actually either diluting 239AA to vanishing point, or otherwise Manoj, rendering it unworkable. And your lordship's words can have only one meaning, is my humble and respectful submission. I then leave the other 2 or 3 small paragraphs for this. I now come to a very important part of this, which is the larger issue of public service commission, but in particular Jammu and Kashmir. That is coming here. Now this is very important. It's a little conceptual. I did put it, but I did not put it quite like this for this, which I'm now doing. So, Lordship, it's not, of course, fully here captured in writing, but this is the heart of the matter. And this also answers the query which the Honorable Chief Justice asked Mr. Mehta. Let me first give you, Lordship, point number 2. Well, sometimes things might sound simple, but from the simplicity, well, it's closer. If that is so, Manas, it is common ground that Mr. Mehta exercises power only over UT. As far as my case is concerned, Delhi or Jammu and Kashmir. If a concept of a service commission is anathema to a UT, how does Parliament exercise it? Cannot. We'll come to Jammu and Kashmir immediately. If conceptually the 2 are anathema, Parliament is today, Manas, Parliament oblique UT Parliament, if I may use that word. My Lord is not considering Parliament in state and Parliament in Parliament. Your Lordship is considering a third avatar of Parliament, Parliament with UT. Because if UTs cannot have service commissions, then Parliament cannot enact law. Parliament cannot create either the Public Service Commission of J&K or for that matter Delhi, because as my Lord Chief Justice noted in the opening, this is a argument applies across to UTs. No, all UTs.
The argument, no, the argument that would be really an unfair, assessment of his submission.
Yes.
He doesn't say that you cannot have a PSC or that you cannot have a service for a UT. The argument, for instance, he says, well, you have a service, you have the AGMAT services for UTs, for instance. The point is about legislative jurisdiction. His argument is that you can have a service, a common service for UTs, but it's Parliament's power to create that service. Likewise,
I'm coming to that.
Parliament's power to create.
Immediately, please.
He says entry 41 does not apply
Therefore, that's C. I've done
Therefore,
two.
but Parliament has no restricting, has no restriction.
No. I'll be dealing with 97.
Entry 41 not being available
dealing with
would
97.
prevent the state legislature,
Well,
the UT legislature from enacting law.
So, what is the
But
first?
Parliament is untrammeled because
No.
if Parliament has no specific power, in any case you have power under
97
246
don't arise.
code, you have entry
Don't arise.
97.
So, therefore, allow me to develop. So, the argument is that UTs cannot have service commission power. Let's leave aside Parliament. UTs don't have?
No. A UT cannot legislate to set up a service.
Yes, so UTs have no power about the public service commission.
No, but Parliament has the power.
No, now, Parliament.
Because Dr. Singhvi, there cannot be a legislative vacuum in India at all. Or in any country.
This is a created.
Because there will be new subjects which will emerge, there will be unheralded subjects. Power has to exist somewhere.
Yeah, definitely.
To legislate.
Whereas what is happening is they are creating a legislative vacuum. Now, I am not reached 41 yet, but just bear with my first two propositions. The argument is that a UT with a service commission is anathema. Let's leave aside Parliament. Conceptually, the UT doesn't have. And because UT doesn't have, then when you go to list 2, which the UT can enact over all the items of list 2, minus 1, 2 and 18, UT can't act under 41. Right, Manas? Let's leave aside Parliament. So, Manas, first curious thing, UT can act under all legislations. There is no specific exclusionary article in the Constitution which says UT can act under 40, 50 list 2 entries, but not under 41. But by implication, UT cannot act. That's my third point. Now, what is the fourth point? Parliament could not have enacted either Jammu and Kashmir or if it wants to try under Delhi, except under entry 41. Nothing else.
Why?
That's my submission. Allow me. Let me do.
You know, Parliament.
Entry 41 is a direct.
No, that would suffer from a fallacy, you know.
Yeah.
Parliament's legislative authority is untrammeled in.
No, with respect, your lordship has held repeatedly.
That's why, as I said earlier, Chief Justice Venkatacharya called this ragbag legislation. No, when he was referring to the taxing legislation, he says ragbag legislation, which is traceable to a lot of powers which Parliament has, if not anything, 97.
No, with respect, repeatedly held by your lordships, repeatedly, not once. 97 doesn't enter the picture where there is a specific entry in list 2. Repeatedly, that has to be, Malas. Otherwise, there will be no federalism. Malas, if 97 became, as your lordship put it, the ragbag,
then
there will be no federalism because list will be swallowed up.
Dr. Singhvi, there also there's a problem with the argument. I'll tell you why. This will apply where there is a specific entry which confers exclusive legislative jurisdiction on the states.
Yes.
All right. So for
Which is 41.
Entry 18 of list 2, land, that is to say land tenure, 41. Land revenue, etc. So Parliament cannot exercise power under entry 18.
41, Malas. Direct entry.
No, but here what happens is, Parliament has powers over everything.
No, with respect, everything in list 2.
Yes.
Not generally. No, with respect, Malas. Parliament becomes the UT in the state list.
Right.
It doesn't mean Parliament starts exercising in the UT powers under some other list. But it's the whole idea, your lordship judgment says so.
But Dr. Singhvi, Parliament, even in relation to a UT, can exercise powers under list 1.
Under the entire list 1, it always can. List 2 is available to Parliament. There's no point of having a UT.
The power to set up a public service commission within a UT can be traced to entry 97. The rest of the
it can't because entry 41 occupies. No, with respect.
Article 248.
Mr. Jain.
Is a residuary power.
At the moment, let me. Now,
Article 4 is.
Please appreciate this. Your lordship is not considering a situation where Parliament chooses to pass a public service commission law for Delhi. Nobody is saying they can't pass.
That's
what my lord is considering is.
No, we were therefore saying
that your lordships cannot have the power of the state, that is the UT legislature, to deal with 41, despite Parliament not having exercised. Now, in that a subsidiary point came in, that where is Parliament's power traceable to? Your lordships, in fact, formulated the question in one way and then said if there's nothing, it will be 97. There is nothing, is the gap in the reasoning. It is assuming what is sought to be proved. There is something. There is entry 41. No entry can be more direct than 41, Whereas your lordship, the Constitution bench, have said 10 times.
There are two questions really.
And your lordship has said
one, can the Delhi legislature set up a state public service for Delhi? One.
The answer is yes, but you should go on.
2, assuming that the power is not given to the Delhi state legislature, can it still exercise executive authority over the area?
Answer to both is yes, because the answer is yes in the first case, therefore the answer is yes in the second case. Give me a minute. Just take a concepts are most important in these things, not the minutiae. Take the list 2. It is common ground until you come to 41. There on every item of list 2, Delhi Assembly sitting in Delhi, it is passing laws. Every day it is passing laws, every item of list 2. Forget 1, 2 and 18, I'm not talking of 1, 2 and 18 and 16.
Does the enactment of part 14 take away that power?
That was separate. Allow me to come. A very strange proposition is told to your lordships. I don't want to deal with it now. That Prem Kumar Jain says part 14 and 312 will apply. In the same chapter, same part, same section, 309 will not apply. It's the most remarkable reading of context in the Constitution. Please leave it aside. I'm coming to that. People forget, my learned friends have forgotten, that Prem Kumar Jain was a part 14, which has both 309 and 312, 3 sections apart. Same chapter. Your lordship has 1,000 judgments that unless some extraordinary words of the Constitution say your lordships can't apply X to 312 and Y to 309. But let us leave that aside.
Yeah.
Now, it is common ground that in every entry of list 2, we are suddenly told that without pointing to your lordships any article of the Constitution, you can't do it in 41. Now remember,
Dr. V, is there any other entry in list 2?
Yes.
Which conceivably it could be argued is not applicable to a UT?
Exactly. I took your lordships almost 3/4 of the way down.
Right.
I read about 40 entries or 35 entries.
Right.
Well, once your lordships 239 AA chooses to exclude 6 entries, why will your lordships at all go down the path of being told to imagine that some more are impliedly excluded? Well, these are fundamental principles of interpretation.
Or is the word insofar as is applicable really intended to be a word which says with such
mutatis
mutandis?
Well, as I argued with you, well, it is nothing but mutatis mutandis. It fits in perfectly.
So far as may be applicable means
well,
mutatis mutandis.
Greatest humility.
That's your
intended to mean mutatis mutandis because we are dealing with a sui generis creature. Once your lordship takes that view, it harmonizes everything. Now allow me one more thing. So my lord is today being told that 41 being as it is directly dealing with the subject. I am right here and now saying for the 10th time, if Mr. Mehta chooses to pass a law on 41, your lordship will be dealing with a different situation. What is the problem? Having not passed a law in 41, having passed no law in 41, why is he going back to 97? Note that judgment, Justice Rumapal put it very well, in that judgment. Give me that. There are any number, it has to be. Otherwise, if you use a residuary entry to trample over list 2, then you are parliament. You have admittedly a UT. Well, this is an example of being hoist on your own petard. You have a UT. You have enacted a law, but when faced with the directive of a public service commission for a UT, and your lordship in the opening asked me, UTs include Delhi and non-Delhi. So it can't be a law that UT means different for Delhi and UT means different for Jammu and Kashmir, as far as the concept of UT is concerned. Now, Malas, how did you enact a law except under 41? When your Lordship put that question, the answer is no, I elected. First of all, there's no answer. Your Lordship Malas gave, if I may say so, both sides of the coin. If you did not do under 41, the only power is 97. Because of course, we would not Malas expect. Is itself indicative of the fact that this is how the government of India stand. Not that there is any estoppel here. Nobody is arguing any estoppel in constitutional law. But your lordships can take it. The government of India never dreamt of 97.
No, but the power is there. There's the constitutional
right.
power is there. Then
now just see 41.
From the judgment in Dhillon, it has been always said. For Parliament, you only ask whether there is a subject in list 2. If it's not in list 2, then of course.
Now just see list 2. 41. There cannot be words more directly occupying. State Public Service, semicolon, State Public Service Commission. But there can't be more direct words. Your Lordship has held by implication entries to occupy with much lesser words. My Lord is absolutely right. Absent 41, you might, I'm not conceding because I doubt if a government of India, which is given by your Lordship's constitutional bench power to act for a UT under list 2, can start acting under list 1. That is another thing. Your Lordship constitutional bench makes it clear that the difference between a regular state and a UT is that Parliament can act on list 2 subjects. Now, suddenly you go to 97 on general principles is not allowed. Kindly see the judgment. Give me the citation. 2000,
669.
Give me the citation. 2005 to SCC 669. Well, these are many judgments. I only brought it up when your Lordship suggested 97. I can take out many more in my note.
What, 97?
It's about the residual entry.
2005?
669.
2005, volume 2, SCC 669, para 7, Malus. I'm only on the 97. I'll give more judgments, Malus, because this came up right now. That's why.
Logic is not applied.
Right? Given because it happened now in the court, so I'm just taking out the right one. Now, let's kindly continue. I'll come back to it. So, my Lord has reached my 4th aspect under this Public Service Commission, the J&K aspect. Well, it's my 4th point is that J&K is relatable to an exercise of power by Parliament, qua a UT, only and only under entry 41. That's my humble submission.
Exercisable, relatable to the
exercise of parliamentary power for a UT, qua a State Service Commission, under entry 41. Now turn to my para 5, para 2.
Yes.
Please do it again. Now, your Lordship can now read with me my submissions, para 2.
Para?
2. Part 14 envisages services of a UT. Lordship, you got that heading?
Yes.
It was argued by the learned solicitor that neither a public service commission for a UT nor a public service of a UT is permissible under scheme of constitution, particularly part 14. This is clearly incorrect and belied by Parliament's own express understanding. The below provision of the Reorganization Act, these are important words, just read with me a little slowly, demonstrate without any doubt that public service for a UT, as also a public service commission for a UT, are not just permissible, but that part 14 in fact envisages them. This is apart from Premchand Jain, which I am coming to. I am reading section 90 of the J&K Act of 2019, is quoted there for convenience. Other provisions, nothing in this section or in 89 shall be deemed to affect on or after the appointed date the operation of the provisions of chapter 1 of part 14 of the Constitution in relation to determination of the conditions of services of persons serving in connection with the affairs of the Union or any Union territory. As clear as can be, part 14. Now continue, Manoj, kindly continue. All services prior to the appointed day rendered by a person, if he is deemed to have been allocated to any Union territory under 89, shall be deemed to have been rendered in connection with the affairs of that UT. Then, if he is deemed to have been allocated to the Union in connection with the administration of the successor UT, shall be deemed to have been rendered in connection with the affairs of the Union. Then, provisions of 89 shall not apply. Now, 91. Provisions as to continuance of officers in same post. Every person who immediately before the appointed day is holding or discharging the duties of any post or of office in connection with the affairs of the existing state of J&K, in any area which on that day falls within one of the successor UTs, shall continue to hold the same post or office in that successor UT, and I underline this, and shall be deemed on and from that day to have been duly appointed to the post or office by the government or other appropriate authority in that successor Union territory, provided that nothing shall be deemed to prevent a competent authority on and from the appointed day from passing in relation any order. Now, 93 is very important also. Provisions as to State Public Service Commission. This is Parliament acting in a UT only under 41. The Public Service Commission for the existing state of J&K shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. If it is insofar as applicable, you can't have the power, then how can you pass this law once? This provision can't exist. This provision of a parliamentary law is negated by the Government of India's own argument, if this argument is correct, which I say it is not. Then, today, please remember, we are not about Parliament's power to pass a similar law as J&K for Delhi. We are about a very remarkable proposition. Absent even an attempt by Parliament to pass a law about Delhi, Mr. Singhvi can't act on that entry 41. That is the proposition your Lordship is addressing. And the fact that he can pass a law and I can also pass a law perfectly harmonizes. And if I can pass a law, obviously I have executive power, perfectly harmonizes. Why should your Lordship have to travel beyond 41 to a Central Union Public Service Commission in entry 70? A Union Public Service Commission. Why, Why does the Lordship have to travel to 97, which is a residual entry? There is a direct occupation of list 2 by entry 41. Also, please note, to complete this point, it is because of 246, which your Lordship noted in the pre-afternoon session, that Parliament can act under list 2 at all. Otherwise, Parliament can't just come rampaging into list 2 just because it's a union territory. It is list 2 which, 246 which allows it. So it perfectly harmonized. 246 takes you to list 2. List 2 has got entry 41. Parliament is welcome. I am welcome. No need to go to either entry 70 or entry 97. That harmonizes the entire circle. Now let's see how this is fortified. Your Lordship has read just now part 14 in the Act of J&K reorganization itself. It is mentioned and quoted by me. Now kindly turn to part 14 of the Constitution, textually. Is this interpretation even statable, is my question to myself. Does your Lordship allow it for ordinary contracts or statutes or in any constitutional provision? The interpretation canvassed by the Government of India. Please come to part 14 starting. It starts with 308.
Yes.
In services under the union and the states. So here, just give me a second, Manas. Himachal and one other state arose in Prem Kumar Jain. Clearly the title is union and states. So simple argument was made, UT is not covered. Lordship sees the title of part 14.
Yes.
Binary distinction, union one side, state one side, there is no UT. Therefore, the High Court in the case of Himachal, held, sorry, out you go, you are a UT, you are not covered. Directly on point, Delhi High Court, and equally directly reversed by 4 judges of your Lordships. Very simple argument, see the title, services under union and states, therefore no UT. Now read 309. In this part, unless the context requires the expression, state does not include. Now let us come to 309. This is 309. First read 312. 312, no? First read 312. I'm sorry, before that, would my lords note that there is nothing, no special provision which suggests that what will apply to 312 will not apply to 309. Now first start with 312. Go in reverse order first. 312 is even more important. It is all India services. Malas, this is a little important. All India services includes the basic large service, of course IAS, etc., and AGMUT. Whereas with deepest respect, the Government of India, in trying to defend this case willy-nilly on any ground, is killing the AGMUT cadre. The AGMUT cadre cannot exist if this argument is correct. Now read 312. Notwithstanding anything in chapter 6, if the Council of States is declared by resolution supported not less than 2/3, it necessary to expel national parliament.
After Goa becomes a state, now it's clearly the AGMUT cadre covers a state as well as the union territories. Likewise, Mizoram is also a state.
That's right. That's right.
Tripura also.
That they've created, they especially applied that cadre to that. But today, Malas, in fact, need not read it, just see 2 words, Malas. 3121 is one or more all India services, 4th line. That line alone has to be underlined. In 3121, one or more all India services. And then, subject to regulate recruitment conditions of service. Then, number 2, clause 2 talks of IAS and IPS. Let's leave judicial service in number 3, and 4. 3 and 4 are judicial service. I hope I'm clear. Now come to Prem Kumar Jain. I'm sorry, to complete. See 309 also. 309 actually is more in my favor because it is subject to this constitution, which means it is subject to 239AA also. 309 opens with the words subject to the entire constitution. Therefore, subject to 239AA also. In the same chapter, same part, 3 clauses apart. Then read Prem Kumar Jain with me. Subject to the provisions of this constitution, acts of appropriate legislation may regulate the recruitment and condition of service of persons appointed to public services and posts in connection with the affairs. Provided, the proviso is important for my purposes, last 4 lines of the proviso, where I'll read the whole slowly. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed. Now mark these words. To such services and posts until provision is made in that behalf by an appropriate legislature. It's a transitional temporary provision. Until provision is made in that behalf by an act of the appropriate legislature and any rules.
Executive legislation.
I beg pardon?
Executive legislation.
Executive. Yes, please. Now, nobody is saying that if you choose to act and make a law, you can't do it under entry 41. Question is, having not done it, you are saying the appropriate legislature, Delhi can't do it. Because I apply the entire constitution without an exclusionary article to all the entries of list 2, but I exclude entry 41 by implication. Malas, this is, and remember, Malas, the impugned notification is not a statutory, not a constitutional, it's an executive rewrite, adding a fourth clause to 1, 2, and 18. Malas, your lordships have to face that point, Malas. You've got 1, 2, and 18 the constitution gave you, and by an executive impugned order, 2015, you are adding 41 to 1, 2, and 18. Malas, your lordships, with great respect, no canon of interpretation is told to your lordships. Same chapter, Prem Kumar Jain, 3 sections apart will not apply. Now turn to Prem Kumar Jain. Yes. 52. Bookmark 52, page, I'll use yours. Just see para 2, 7, and 8 I read. I'll not read again. Mr. Jain read it also. Exactly the same point Delhi High Court held and reversed by Supreme Court. The state here, or the UT here was Himachal and Delhi. Where is it here? Here, Malas, Delhi and Himachal, joint cadre was involved. A new cadre of service, may I read, Malas, very quickly? 4 learned judges, and Malas, with respect, Mr. Jain may have dealt with it later. It doesn't find mention in Mr. Mehta's submissions. Neither 52 pages nor 90 pages earlier. A new cadre of the service was constituted for the Union Territory of Delhi and Himachal, and recruitment to that cadre was made directly without complying with the requirement of Rule 4.1 of the IAS rules, etc.
I read it. It's part of my volume, and I read it today also.
That's all right. I'm just saying it's not part of your submissions.
Submissions. I read it. It's part of my today's submission. And
now I've been gone into.
Annexed it and read it. Then already reference.
Read from the 4th line. The rules were amended on December 21 by providing for a joint cadre in relation to the UTs and the Northeast Frontier Agency, and the central government formulated the aforesaid scheme to extend the Delhi Himachal cadre to all UTs by absorbing the officers of that cadre and by appointing it to officers of the Indian Frontier Administrative Service and all the union territories. The joint cadre for all UTs was brought into existence in 1968 January. Hereinafter referred to, skip that. The petitioners in the High Court challenged the creation of the new joint cadre for all the UTs and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of 312. Why was this? One line, simple. As it was not common to the union and state, inasmuch as a UT was not a state. Well, as joint cadre means it has to be government of India and a state, or 2 states. Now, Himachal is not a state, therefore out you go both the categories. That's a simple argument. Now let's come to 7. I think it's always changing. Now your lordship will come straight away to para 7, where they compare the provisions, and then come to 8. 8 is enough.
58.
It's been read, marked by our lordships, but just note, directly the contention reversed is at 7th line before the end of the paragraph. The High Court was therefore wrong in taking a contrary view and in holding that UTs are not states for purpose of 312 and the preamble. All that Mr. Jain is saying is that contextually, UTs are states for 312, UTs are not states for 309. That your lordship decide. Any great article in the Constitution so suggests? Is the subject of 309 Arctic Pole and the subject of 312 Antarctic? Is the subject of 309 directly opposite to the subject of 312? Imagine the difficulties that arise if UTs are states for 312. UTs are not states for 309.
What do you have to say about the legislative history argument on part 14 with the
Well,
SCR?
it's completely unnecessary. Completely unnecessary. Legislative history, Manas, has been legislative history has been legislative history is completely, it's very good to have all these long submissions with all the details. Very useful to have them, but they have no relevance to the case for the two simple reasons. It is superimposed by 239 AA in 92. It is superimposed by a Lordship General Constitution Bench, and it is interpreted by Prem Kumar Jain, which doesn't find a mention in this legislative history. So, Malas, yes, it arose historically because your Lordship knows we had 4 categories of states. We knew we had Raj Pramukhs. That's all very valuable, but it doesn't address the issue. That is, it would have been relevant pre-Prem Kumar Jain. That look, it's a grey area. It's a tabula rasa. Your Lordship has not yet painted on it and decided that UTs under Part 14 are states. Post Prem Kumar Jain, where is the relevance of any history? Because your Lordships were called in only for that reason. Your Lordship had a fight only for that reason before the High Court, which your Lordship resolved. After that, Malas, whatever Part 3 state was, we know Malas, Ajmer and these other states are all there. What is the point of all that? Now, Malas, kindly come to some very interesting rules which are not shown to your Lordship. Malas, your Lordship has shown transaction of business rules for almost 1 hour. Kindly see if any of it is remotely relevant after your Lordship sees 4 rules. I am now, Malas, in para 3 of my submissions. Whereas transaction business rule only says, generally, what is mine, it is divided like this. What is mine is the operative word. It doesn't say that if I divide it like this, you get what is not yours. But
now, now, Dr. Singhvi, we got your submission. Now, insofar as the All India services are concerned,
that is the rules now coming up.
Right. We'd like you to address
straight away, straight away. It's about 4 or 5 rules, and in fact, not even 4, 3 rules and 3 paras of finance. These I need to show to your Lordship. Your Lordship is serious, it will take 2 minutes to show it. May I read it? May I read it first?
Para?
Allocate, para English 3 months, ordinary 3.
Yes, let's read that.
Allocation of all India services, civil servants in respect of Agmut cadre is done by the Joint Cadre Authority and not the Ministry of Home Affairs. Directly shown to your Lordship's Ministry of Home Affairs, that's wrong. It is, the Act will apply, then a rule under the Act, then a notification under the rule, or a resolution shown to your Lordship. The resolution is shown for a very different purpose. What your Lordship is told is under a resolution, MHA looks into it. That was a temporary arrangement, then there were rules, first Act, Section 3, then Rules 4, and then a notification of 25th April 1995. And it's clear that UT is a state. And one more point before I read it. In all these joint cadres, the whole idea, what is the meaning of joint cadre? My reps exist and act and decide as much as their reps. My chief secretary sits there with us. Joint cadre is collegiate. It doesn't mean he's excluded, but equally doesn't mean I'm excluded. Now let's kindly come. The Joint Cadre Authority is established under Rule 4, take out the reference, of the All India's Joint Cadre Rules of 1972, which are statutory under 3.1. Now the order is the reverse. 3.1 comes first, then comes Rule 4. Section is 3.1, Rule is 4. The authority is a committee comprising representatives of each of the government of states, constituting the Joint Cadre. The AGMAT joint cadre has been established under this rule by notification dated 25/4/95. That's the third one. Act, rule and notification. Whereby Delhi, along with Arunachal, Goa, Mizoram, is represented in the joint cadre authority through its chief secretary, whereas the other union territories are collectively represented by the MHA. This distinction itself is important. Delhi has a chief secretary sitting there. MHA acts for a few other smaller UTs or whatever your lordship will call them. The function of the joint cadre authority under the All India Rules of 72, the fourth point was, under Rule 5.1, quote, to determine the names of the members of the All India services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their services shall be available to that government. Just pause here, brothers. Look at the bizarre result which is being canvassed before your lordship. Even at the time of allocation, your lordship knows civil services. I am an officer bullets of the central service, or IAS. Cadre is, let's say, whatever, UP. Today, from Delhi, some ministry, I am to be posted. At that time itself, a joint cadre will operate for a UT. Where I am sitting, he is also sitting. Look at the bizarre consequence that after I am posted, even at the time of posting, the chief secretary has a say. But after I am posted, the state of NCT cannot decide whether to post with Mr. Farasat, to post with Mr. Rahul Mehra, post with Mr. Chadda, or to interchange them every 6 years according to whatever, 6 months according to whatever they want. This I am showing given at inception. Now see those rules. First turn to section 3.1. Bookmark 45, page 3949. Well, with respect, this is actually driving a coach and four through a very well-established harmonious scheme. It's only a question of requiring a lordship's interpretation. Imprimatur, not even interpretation.
3949.
Yes, 3949, bookmark 45. Show me now. Your lordship saw this briefly, but in view of our learned argument, it's very important to see it. In this, your lordship will see, I think rule 4 and 5 is enough. Why does it not go up and down? Do not scroll. You scroll it for me. Yes. Wait. Let me do. Does my lord have it, please? 3949, All India Services, Joint Cadre Rules of 1972.
Yes.
See, I want to show 3.1 of the Act. You are not showing 3.1 of the Act.
Yes.
May I just read 3949 on the top? Has my lords got it?
Yes.
The title is All India Services Joint Cadre Rules of 1972. It is not disputed that things like AGMAT, etc. are joint cadres. Not even disputed. In exercise of the powers conferred by 3.1, this comes at the top. Lordship will note 3.1. It's in the file. I'll give you the page also. It doesn't have to be read. It's Act.
Bookmark 9.
The central government, after consultation with the governments of the states concerned, hereby makes the following rules. Well, just mark that section is under the All India Services Act of 1951. It is at page 820, bookmark 9. That section 3.1 is 820, bookmark 9.
Dr. Singhvi, we don't want to rush you. Are you going to finish today or you will spill over a bit tomorrow?
I mean, I don't want to ask your Lordship to sit so late. Give me 1 hour tomorrow, I'll finish it off. First, your Lordship will assemble here and finish it 1 hour, then your Lordship will take your normal.
1 hour more you want?
Well,
He said
I don't want to
90
just,
minutes.
Mr. That's very unfair coming from him.
No, no,
No, not at all.
No,
This
that's
is
a
a
very,
matter
I
of-
mean, I can understand him.
Dr. Singhvi,
My
it's
learned
not
friend
too late.
argued
We don't
for my
want to
entire
like a
150
civil appeal or a
minutes.
criminal
60
appeal where
minutes
we
became
can come up
150
with-
minutes.
and we reach on.
I am taking into account 150 minutes of argument.
Right, that's
I will
why I
finish
asked
in
you
1
that.
hour tomorrow. I'll do it even in 45 minutes tomorrow, first thing in the morning. Constitution bench, well, I mean, I have a problem with it. I can't help it. My learned
Dr. Singhvi will time tomorrow.
I'm very deeply obliged.
Keep it first on board.
The Lordship will assemble first.
One clarification.
And then our regular boards will start.
I'm very deeply obliged.
Only one,
Very deeply obliged.
one clarification. My today's submission may be read in conjunction with the earlier. It's not
Yes, yes.
substitute.
No. Obviously, so it's a supplementary.
Supplementary.
We also thought that, Dr. Singhvi, you've made your point. We can also reflect on it. If we have some queries, we can pose you. Otherwise, we will not have the opportunity of posing.
Certainly, man, certainly.
Can
I
also-
may even take lesser than 1 hour.
We can also now sort of reflect on what has been argued and
Deeply
then-
obliged.
But would my lords be assembling at 10:30?
Yes, yes.
Yeah, we'll take it up at 10:30 only, right? 10:30, want to do it in
Otherwise, the Lordship, other benches will be impacted.
So we'll keep this matter between 10:30 and 11:30. Then we'll take our mentionings so that my learned brothers and sisters are free for their regular work. And then we'll start with our regular work tomorrow.
Obliged, very, very deeply obliged.
Please. Brother Narasimha and I will come back for the mentioning in just now.
Grateful to you.
1 hour, no? 1 hour.
1 hour.
I will not exceed a minute. Lordship may time me. I'm not going to exceed. Certainly.